Good morning. We're on the record. I apologize for the late start this morning. We had some internal work to do, so I apologize that we started late this morning. Good morning, everyone. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2571 et seq. Of the Open Meetings Act, OMA, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central Meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Bobby Cato.
Cato, present.
Ms. Jenny Henson.
Jenny Henson, present.
Mr. Edward Grandis.
Edward Grandis, present.
The board has 5 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. We have 6 cases on our morning calendar today. And once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. And I know that there are a lot of folks online today to participate in a public hearing today, but I'm going to go through my calendar, which should run quickly. And once I've gone to the calendar, then I'll call the participants for the public hearing. So as per our public calendar, the first case in our calendar is a protest hearing status case number 23, PRO 00044, Tai Chi Bubble Tea, license number 124100. This case has been canceled due to the approval of a settlement agreement. See board order number 2023-333. The next case in our calendar is case number 20, another protest hearing status, case number 23, PRO 00041, Streets Market, license number 123846. Good morning, Mr. Oriana. Can you please elevate the rights of the licensee and the protestant in this case, please?
Good morning, Chairman.
Good morning, sir.
Gwendolyn Lohose, your access has been elevated. And that appears to be all, Chairman.
I think you should find, this is the case, I think Andrew Klein, is Mr. Klein on the line?
He does not appear to be online.
All right,
This is Gwendolyn Lowe's, Commissioner Lowe's from ANC2E.
yes, ma'am.
The parties have agreed on a settlement, and I believe they're signing it today. I am on behalf of the ANC, but I can also probably speak for Mr. Klein that I believe he has the settlement agreement, and I have in writing that he is
Hold on,
signing
hold
it.
on. I think Mr.
Oh,
Oriana, there's a
Mr.
camera on
Cameron's.
Mixon. All right,
Thank you.
thanks. All right, Mr. Mixon, can you identify yourself for the record, please?
Hello, Cameron Mixon, attorney with the Veritas Law Firm, counsel to the applicant.
Can you spell your name, please, sir?
Cameron, Cameron, and Mixon, Mixon.
Good morning. Ms. Lossie, can you again identify your spell and state your name for the record, please?
Gwendolyn Lowe's. It's Lowe's, not Losey, Lowe's. ANC 2E06 Commissioner.
Spell your name, please, ma'am, for the court.
GWENDOLYN. Gwendolyn, and Lowe's, LOHSE. Thank you.
All right, thank you. So as represented, I guess the parties are probably this matter will be settled, but just want to, as stated, I'm sorry, Mr. Mixon, do you want any representation you wish to make, sir?
Yes, I have provided the applicant with a final version of the settlement agreement for his signature today to be provided to Ms. Lowe's later today.
All right. So if just want to say that this matter is scheduled for, if this matter is not scheduled, if this matter is not settled, then it will be scheduled for a protest hearing on July 12, 2023 at 1:30 p.m. Good luck with your settlement. As soon as you have a signed agreement, please provide it to the agency for the board's review and approval. Okay.
Thank you.
Thank
Have
you.
a great day. Thank you. All right. The next case on our calendar is case number 23 PRO 00045 ZOOZ, ZOOZ, license number 124023. Ms. Oriana, can you please again elevate the license, the rights of the licensee and the protestant in this case, please?
Hello, Cameron Mixon. Also,
Hold on, Mr. Mixon. Hold on. I need we need to elevate the protestant.
Well, I think that's what he's going to clear up. The protestant.
Mr. Mixon, go ahead, sir.
Hi. Also, Cameron Mixon, also counsel to the licensee in this case, Zeus. We are in the midst of the settlement process and are awaiting final confirmation from the protestants.
And is the protest, did the protestant ask you to fill in for them today, sir, or why are they not here today?
I'm not aware of the protestants' decisions with respect to today. I imagined that they would be here, but I had last spoken to them yesterday.
All right, who's the protestant? And who's the protestant in this case, sir? And Mr. Mixon, if you have a camera, I prefer when I'm speaking to folks that if they have a camera, they turn their camera on, sir. Bob Link, okay, all right. So if you have a camera, Mr. Mixon, I would appreciate if you can turn your camera on.
Yes, sir. To answer your question, it's ANC 60, of which, yes, Bob Link, I believe, is commissioner.
I see that in the chat that we've asked for the protestant to identify themselves. And if the protestant failed to identify themselves, then I need to dismiss the protestant unless say, yes, good morning, sir. Good to see you. I'm not familiar with you, sir. So it has always been my position that I ask everyone who participates in front of me, unless there's some reason that you appear on camera, sir. All right.
Understood.
Thank you. All right, so let's ask, is the protestant from ANC 6B online? No one has identified themselves as representing the protestant group. This matter was scheduled for protest hearing status at 10:30 this morning. It is 10:58. I've called the case and the protestant is not here. There, I'm going to make a motion that the protest be dismissed. Is there a second?
Short, I second.
Mr. Short, I second the motion. I'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
Mr. Anderson, I agree. The matter passes 5-0-0. What this means, sir, is that the protester will issue a board order dismissing the protestant. The protestant will be given 10 days to provide the board reasonable notice why they failed to appear here today. Failure on the part of the protestant to give reasonable notice to the board is Mr. Is Chandler Jaramaran, is he the protestant in this case? I believe he's from ANC 6. Mr. No, all right, then you're not the protestant in this case. Okay, so failure by the protestant to give reasonable notice to the board why they failed to appear here today, we will dismiss this matter. And the agency will direct the board will direct the agency to move forward with issuance of the license. Okay? All right, so have a great day. Thank you. All right, I guess the next case in our calendar is case number, we have a show cause hearing status, case number 22-251-00023, Brooklyn. Mr. Oriana, can you please elevate the rights of the licensee and the government in this case, please?
Sure. Bisola Oni, your access has been elevated. That is all, Chairman.
And I assume Mr. Mixon, this is your case? All right, good morning. Ms. Oni, can you please spell and state your name for the record, please?
Yes, good morning. Bisola Oni, Bisolaoni, Assistant Attorney General with the Office of Attorney General.
Mr. Mixon, can you please spell and state your name for the record, please?
Cameron, Cameron, Mixon, Mixon, Attorney Counsel to Brooklyn.
All right, good morning. Ms. Oni, are there preliminary matters in this case?
Not at the moment. We did send an offer in compromise to Mr. Mixon, and we haven't got a response yet.
All right, thank you. All right, this matter is scheduled for a show cause hearing on July 12th, 2023 at 10:30 a.m. If this matter goes to a show cause hearing, both parties are required 7 days prior to the hearing to disclose documents and witnesses to each other and also to the agency. Failure by either side to disclose documents or witnesses 7 days prior to the hearing that will be relied on at the hearing, the board is empowered to prevent that person from that side from moving forward. Are there any questions?
Can you please repeat the date of the show cause hearing?
July 12th at 10:30 a.m.
Thank you.
All right. Thank you very much. Have a great day. The next case in our calendar is case number 22 CIT 00201 Half Smoke, license number 100855. Mr. Oriana, can you please elevate the licensee in this case, please, for Half Smoke?
Andre McCain, your access has been elevated. That is all, Chairman.
Thank you. Mr. McCain, can you turn your camera on, please? All right. Good morning, Ms. Oni. Can you please identify yourself for the record, please?
Bisola Oni, Bisolaoni, Assistant Attorney General with the Office of Attorney General.
Mr. McCain, can you please spell and state your name for the record and identify yourself, please, sir?
Andre McCain, owner, Half Smoke.
Spell your name, please, sir.
ANDREMCCAIN.
Good morning, sir. Ms. Oni, are there any preliminary matters in this case?
No, not at the moment.
Thank you. Then this matter is scheduled for a show cause hearing on July 12th, 2023 at 10:30 a.m. What this means, sir, 7 days before the hearing, both parties are required to file documents and witnesses that they will rely on at the hearing. Failure on either side to exchange documents and witnesses with the other side and also share a copy with the agency. That means that the board is empowered to prevent you from relying on documents and witnesses if they have not been disclosed 7 days prior. Any questions?
I believe we were offered an offer in compromise for this.
Yes, sir. I don't know. That's what the government said, but you guys can, if it's not accepted today, you can negotiate and provide the board with a written offer, and the board will review it and approve it if that's submitted prior to the hearing or even at the hearing, but preferable prior to the hearing.
Okay.
Yes, we sent an offer in compromise. This is Assistant Attorney General's Hodgemiller's case, but I was covering for her, but I did send you an offer in compromise via email, and you can just respond to that email.
Thank you.
All right. So, any questions?
No.
So, if this matter is not settled, then we'll see you at a hearing. We'll see you on July 12th, 2023 at 10:30 a.m. Thank you very much. Have a great day. And all right. So, prior to our public hearing, the next case on our calendar is case number 23 CMP 00029 Tres Creole Catering, license number 111150. This case has been canceled due to the offer in compromise that has been provided to the board for its consideration. Let me move on to the rest of our calendar for the rest of the afternoon. For afternoon, we had a protest here in case number 23 PRO 00136 TG Cigars, license number 97774. This case has been rescheduled to June 28th at 1:30 p.m. See board order number 2023-336. The next case in our calendar is case number 22 PRO 00153 TAP 99, license number 116883. This case has been continued to August 2nd, 2023 at 1:30 p.m. See board order number 2023-342. The next case in our calendar is case number 23 PRO 00021 Maidan, license number 106450. This case has been canceled due to submission of a settlement agreement for the board's review and approval. The next case in our calendar is case number 23 PRO 00015 Tom's Watch Bar, license number 119403. This case has been, the board granted the motion to consolidate this matter with case number 23 PRO 00046, and that the protest hearing is now scheduled for August 29th, 2023 at 1:30 p.m. See board 123. I don't have the board number at the moment. And the last case on our calendar for the day is case number 22 PRO 00121 MLK Lounge and Restaurant, license number 88787. This hearing has been rescheduled to August 9th, 2023 at 1:30 p.m. See board order number 2023-341. All right. The next case on our calendar, we have a public hearing on the Medical Cannabis Amendment Act. Good morning, everyone. Thank you for joining us today at the public hearing on the Alcohol Beverage and Cannabis Board Medical Cannabis Emergency and Proposed Rules. As you know, the board assumed jurisdiction over the district's medical cannabis program on October 1st, 2020. Since that time, new laws and regulations have been adopted and sweeping changes have been made to the program in a brief period of ABCA's management. Excuse me. The board is holding a hearing today on a second round of emergency and proposed rules. This rulemaking was adopted by the board specifically to implement the Medical Cannabis Amendment Act, ABCA of 2022, which became effective March 22nd, 2023. Amongst other changes, the ABCA legislation allows qualifying patients to self-certify to participate in the program, provides a mechanism for unlicensed cannabis business to obtain a medical cannabis facility license, creates new license categories and endorsements, creates various benefits for qualified social equity applicants and medical cannabis certified business enterprises, reforms the license application process, and allows advisory neighborhood commissions to protest the issuance of cultivation center, manufacturer, retailer, and internet retailer licenses. The rulemaking also makes various technical changes and renumbers the regulations where appropriate. The board's adoption of these rules ensures that the district's program continues to operate optimally for qualifying patients and caregivers who depend on the program for their medical needs. These emergency and proposed rules are also being issued to ensure the economic viability of existing medical cannabis businesses and to ensure that an adequate and safe supply of medical cannabis remains available for qualifying patients. Lastly, the board's adoption of the emergency rules meets our paramount goal of promoting the health, safety, and welfare of district residents. By way of background, the emergency and proposed rulemaking was adopted by the board on April 12, 2023 by a vote of 5-1 and became effective immediately on that date. The emergency rules will expire 120 days from the date of adoption or on August 10th, 2023. Thank you to everyone who is present today to share your thoughts with the board. We received 2 pre-filed sets of testimony and numerous email comments. In reviewing the email comments, it is clear that many of you, if not all of you, are concerned about the provision regarding the limitation of 8 ounces of cannabis concentrated permitted per month for patients 21 years of age or older. I want to ensure the industry and medical cannabis patients and caregivers that the board is well aware of this issue and that we will be revising this issue in our revision of the regulations. I'd like to lay a few ground rules before we begin the hearing. The board received over 35 requests from individuals who expressed an interest in testifying today. For the sake of ABCA, staff, IT, the court reporter, and you, the witnesses, we need to ensure that this hearing is orderly so that parties are properly identified and the testimony is properly recorded. To that end, please know that witness testimony is limited to 5 minutes per person. If there isn't a time left at the end of the day or the hearing, we may permit additional limited comments. When I recognize you to speak and after IT has elevated your speaking privileges, please clearly state your name and the company or entity you represent. If you're testifying on your own behalf or as a consumer, simply state that. I ask everyone for their patience and for their indulgence. This is the largest virtual hearing the board has held. We want to ensure fairness and opportunity for anyone. All right. There will be a 5-minute timer on the that is visible to everyone. Once you begin to testify, you'll have the timer. You will see your time, and I'm asking that everyone comply with the time limit so everyone will have an opportunity to testify today. I've also asked our IT person to post in the chat the witness list. So these are the folks that have informed us previously that they will testify. I will be calling the witnesses in this order. If your name is not on the list, at the end of the hearing, once we have done, please identify yourself and I will allow you to testify. What I'm also going to do is that I'm going to call probably panels of 3 to 4 individuals per time to testify. So I probably will call all the ANCs together. And if at least on the list, if you are identified from the same organization, I will ask that you all testify. I will ask our IT specialist to elevate your rights so you will be all identified. But I will have what I will do. I'm going to ask our IT specialist to each time elevate 4 individuals, a maximum of 4 individuals, unless there's more than 4 individuals in a specific group to testify. So we'll have a group of 4 or more persons on the screen each time identified to testify. If you have any questions, please put them in the chat and we will start. So let me find our list that's in the chat. So you'll have an idea when it is that I will be elevating your rights. So hold on, let me get to my list so I can start call the first panel. So the first panel that I'm going to ask the IT specialist, all right, Mr. Oriana, to elevate. Mr. Oriana, can you please elevate Mr. Chuck Elkins, ANC Commissioner 3D, Mr. Max Ewart, ANC Commission 1A, Mr. Zachary Adams, ANC Commissioner 2B, Mr. Jeffrey Ruckiger, ANC Commissioner, and I apologize if I butchered your name, ANC Commission 2B, and Mr. Chandler Jamarian, ANC Commissioner 6B. Can you please elevate those individuals to testify, please?
They have been elevated. I do not see Max Howard.
All right. So I'll ask everyone to turn their camera on, and you'll also see an on-screen timer for 5 minutes. And I'm going to call. Good morning, everyone. So what I'll ask everyone to do is to identify themselves for the record. So let's start with Mr. Chuck Elkins. Can you, Mr. Elkins, can you please just identify yourself for the record, and I'll start the timer if I can figure out how to do that. Once you identify yourself, I'll start the timer.
Thank you, Mr. Chairman. I'm Chuck Elkins, ANC Commissioner for 3D01.
All right. Good morning, sir. Go ahead, sir.
Well, thank you, Mr. Chairman. In my written testimony to you, members of the board, I make 5 recommendations, but we'll focus on the first 3 in this oral testimony. But I do hope the board will read my complete testimony and the justification for these recommendations. As you know, serving as an ANC commissioner is a voluntary job, so each of us have other lives. In my case, it happens that for 25 years, I worked at the Federal Environmental Protection Agency, where I served for several years as the senior manager of the nationwide air pollution program. And therefore, you should not be surprised that I'm focused on smoke today, that is exposure to secondhand cannabis smoke from the safe use treatment facilities, SUTFs, and the summer gardens. While I'm not an expert in the capture and treatment of the products of combustion of cannabis, it is my professional opinion that the proposed regulations provisions for SUTFs and summer gardens, as now written, could prove to be a disaster for both applicants and ABCA. The problem with the current draft is this. The council was careful in its cannabis amendment to strike a balance between the needs of the cannabis users and the needs of those who might be exposed to secondhand smoke from cannabis combustion at the SUTFs. Recently, a Superior Court judge in the district struck the same balance between users and the public, as you may have read in the Washington Post this morning. Specifically, the council directed, as you know, that the licensee must collect the polluted air, run it through a control device, and ensure that he has eliminated all detectable odor, smoke, and byproducts of combustion so as to prevent any and all public nuisances. The current draft regulation, however, does not reflect this directive. In order for a licensed applicant to be sure he is not creating an SUTF that turns out to be a nuisance, he must become familiar with the construction of airtight rooms, the necessary level of air exchanges in order to capture the smoke, air pollution equipment that will in fact successfully treat the smoke, and the proper discharge of the treated air, which may still smell despite the best control equipment, in order to keep it out of nearby businesses and residences. In fact, not only does the licensed applicant need to understand these technical matters, but so does, I believe, the ABCA board and staff. Of course, one could argue that the board should leave it up to the private sector, the licensed applicant in this case, to figure this all out, letting the board simply enforce the nuisance provisions. However, preventing problems in the first place is almost always easier and cheaper than trying to fix them after the fact. If the board determines that an SUTF is creating a nuisance, the board will need to shut it down. But at a potential loss of thousands of dollars of investment by the licensee, and perhaps in the case of a smaller licensee, drive them into bankruptcy. This drastic action may occasionally be necessary, but it would be so much better to prevent the problems from the start by having the board, the staff, and the potential licensees gain an understanding of exactly what is required in order to be able to create a SUTF that will not be a nuisance in the first place. The proposed regulation provides no such guidance and asks for so little information about the construction and equipment that the board, about the construction and equipment, that the board and the public will not be in any sort of position to head off disasters in the making. The board and the staff need to be told by the applicant in detail what he plans to do, and then the board needs to know enough to tell the applicant whether or not what he proposes to do is likely or unlikely to be successful in avoiding the creation of the prohibited nuisance. So my recommendations are as follows. Delay the SUTF and the summer garden portions of the regulation and hold a separate set of hearings to focus on the technical aspects of running a nuisance-free SUTF and summer garden, and then finalize these provisions separately. Recommendation number 2 is once those regulations revised are in place, initially approve only a very few SUTFs and summer gardens until the board, the staff, the applicants, neighbors, and ANCs learn through experience how these provisions can be effectively and fairly enforced and remedied if they are determined to be out of compliance. I envision lots of problems with having to use an inspector's nose to detect violations. And just to finish on my last one very quickly, Mr. Chairman, suggesting you be very judicious in choosing where these summer gardens are located. Thank you.
Thank you, sir, for your testimony. And we have received your written testimony, and I have reviewed them, and we will take them in consideration. Thank you for appearing this morning. Thank you, sir. All right, Mr. Zach Adams. Thank you, sir. Take your name. All right. Go ahead, sir.
Good morning. My name is
Mr. Adams.
AMS. I am ANC.
Go ahead, sir.
You cannot hear me?
Go ahead, sir. I can hear you. Go ahead, sir. I can hear you.
Oh, okay. You can hear me. Okay.
All right. Hold on. All right. So
my spelled. Okay. I'm ANC for 2B.
All right.
Circle and the west end of U Street. Can you does this?
All right. Let's start over again because I'm having. All right. So I see you've moved the right. So let's start again. Go ahead, sir. I see you've moved the right. So let's start again.
If not, then
All right. All right, Mr. Adams. I don't know. Are you in the same location? Is there anyone else in that area with you who's online? All right. All right. I'll give you another opportunity, sir, to testify so you can. All right, hold on. Go ahead, Mr. Adams.
Can you hear me?
There's a delay. There's a delay, so I hear you like 20 seconds after or 5 seconds after you speak. I hear you like 20 seconds. All right, what I'll ask you to do, Mr. Adams, why don't you log out and log back in? Let me move on to the next person, and then I will come back and call you. Okay, so all right, so let me call Mr. Jeffrey Ruckiger.
Thank you. It's Jeffrey Ruckiger. I'm the commissioner for 2B02, and also my testimony today is based on conversations and other experiences with the ANC, but it does not reflect an official ANC2B position. The cannabis regulations being considered represent a considerable improvement and expansion of the existing regs and have become largely consistent with the existing alcoholic beverage regulation. There are a number of issues that bear further examination and clarification so as to not create confusion or greater burden upon our volunteer commissioners. I begin with section 5200.1 and .2, the distance requirements. This section specifies that a cannabis business other than courier cannot be sited within 300 feet of schools, rec centers, except the main entrance is a commercial or industrial zone. Retailers cannot be located within 400 feet of another. The regs don't specify who performs this measuring. I presume it would be ABCA, and I recommend that it be ABCA to determine that as part of the application intake process and decline it so it does not become something the ANC commissioners have to deal with. In the alcohol regs, section 25-314 uses 400 feet from schools except for restaurants and hotels or another same class establishment at the time of the application. It would be helpful to either make these uniform or clarify why the distance of only 300 feet is suitable for cannabis versus 400 feet for alcohol. In 5421.5, the appropriateness criteria for an applicant are defined. These essentially are the same as those for ABC liquor establishments. It includes residential parking and vehicular and pedestrian safety, including the availability of parking near the establishment. In the alcohol context, this refers to impacts on parking by employees and customers. With respect to grow, delivery, and courier businesses, which would be allowed in mixed-use zones, this could create particularly disruptive conditions without a mandatory traffic control plan required. There was a GoPuff last mile delivery service warehouse on 22nd Street between my apartment building and another building. Their drivers constantly block the alley, frequently preventing residents from getting in or out, blocking trash trucks and moving bins. There was also frequent double parking on 22nd Street, which caused congestion and attendant noise from horns being blown. I recommend a requirement that if a cannabis business that will rely upon or generate traffic in a mixed-use zone or adjacent to a residential zone must provide a DDOT approved traffic control plan to mitigate conflicts or congestion. Seeing that this is a new program that needs to build experience with the many different situations and experiences for owners, neighborhoods, and ANCs, that license renewals be on a 2-year rather than 3-year cycle for at least the first 2 renewal cycles. This will provide a better framework for debugging the process and addressing problems that may arise much sooner. 5417.1 specifies that 50% of all new cultivation, manufacturing, internet, retailers, and couriers are required to be set aside for social equity. It's laudable to build equity into the system. However, this should be refined so that the 50% requirement does not prevent qualified establishments from opening if there aren't enough of the missing operator supply. It also is not specified if the equity ratio is aggregate citywide or is at a quadrant or ward level. 5425 needs better explanation and possible revision. For alcohol applications, the notices go to ANCs within 600 feet of where the establishment is or will be located, and any registered citizens associations. For cannabis, it's all the ANCs in the ward who are noticed and allowed to weigh in or object, and no citizens associations. The rationale for this and the corresponding potential for more than one ANC entering into a settlement agreement with the business must be clarified. Citizens associations, frankly, will be outraged at being excluded as parties to the approval renewal process as something clearly of concern to them. While it may prove expeditious to consolidate all public comment through ANCs, there are situations where a citizens group holds a dissenting view from their ANC. It's important that all residents' views are considered as parties with standing when deciding whether to approve a business. It also must be explained why all ANCs in the ward are solicited. I urge this be made the same as for alcohol licensing. The primacy of the ANC where a business is located must not be subjected to contradiction or dilution by other ANCs. Businesses having a safe use treatment facility and or summer garden should be required. Should be required to have someone who has a certification for emergency medical aid present at all times when open for public use. They would be able to provide immediate aid, such as CPR or using a defibrillator in an emergency until EMS arrives. As we're all aware, the smell of smoked marijuana has become pervasive everywhere in the district, even in and around buildings where smoking tobacco or cannabis is prohibited. Borrowing a paradigm from bars, while establishments may religiously follow the law, they have zero control over customers once they exit the premises, nor does ABCA have any enforcement authority. There's nothing stopping someone from opening a container and lighting up in the street, as police are unlikely to intervene. For what it's worth, I recommend including a requirement that smoke a no smoking zone within 25 feet of property as authorized by DC code, and that agencies include this in their settlement agreements.
All right, can you wrap up, sir? All right, thank you. Everyone, you can submit your written comments to abca.legal@dc.gov. So you still have an opportunity to send your written comments to the agency at abca.legal@dc.gov. All right, thank you. Mr. Jeremiah, you can go and I'll get back to you, Mr. Adams. So, all right, thank you. Thank you, Mr. Rockheiger. Mr. Jeremiah, you can go ahead, please. Please spell and state.
Good morning. Okay. Thank you for the opportunity to testify on this important and timely topic this morning. My name is Chandra J. Raman, and I'm here as an ANC Commissioner for 6B06 and not on behalf of ANC 6B. I currently serve as ANC 6B's Alcohol Beverage Committee and have held the same position for 6 of the past 8 years. I'm here today to propose some common sense recommendations to the proposed rules that will reduce the adverse impact on public health, protect our children, and maintain peace, order, and quiet in our communities. First, let me start with the enormous amount of dry cannabis that a person can purchase by right for personal use each and every month. 8 ounces, that's half a pound. For board members who don't know what 8 ounces or half a pound of dry cannabis looks like, let me show you. This is a 2-gallon bag filled with 8 ounces of dried lawn grass. It's 14 inches tall, 12 inches wide, and 2 inches thick. In my research, I found that you can make about 450 joints with 8 ounces of grass, which if smoked in a month would be equivalent to smoking 5.5 packs of marijuana cigarettes a week or 15 a day. According to the American Lung Association, smoke from marijuana combustion has shown to contain many of the same toxins and carcinogens as tobacco smoke, which we all know can damage the respiratory system. Allowing the sale of 8 ounces of dry cannabis per month coupled with the right to self-certify would be reckless and contribute to increased lung cancer among a list of other adverse health effects. ABCA has been given the charge to control the responsible use of cannabis, and I encourage ABCA to strike a balance between responsible cannabis use and medical need. This can be achieved by lowering the maximum amount a person can buy each month to 4 ounces, but allow for the purchase of additional amounts with a prescription from a doctor. My second point is regarding the availability of a summer garden endorsement for cannabis retailers. In my view, this is premature and fraught with problems. In ANC 6B, approximately 70 to 80% of businesses on commercial blocks are adjacent to a residential property, usually at the rear of the premises. Likewise, many of the spaces that could be used as a summer garden are also located at the rear of the property. This sets up a no-win situation for both retailers and residents because a puff garden would be right next to people's backyards. Specifically, Section 5626.4 only prohibits odor from being detectable on the interior of the dwelling with the windows closed, but does not protect the right of residential property owners and families to peaceably enjoy their backyards and not have to worry about their children breathing secondhand cannabis smoke. Just this morning, Washington Post reported on a ruling that neighbors can't allow their marijuana smoke to affect others, with the judge stating that, quote, the public interest is best served by eliminating the smoking nuisance and the toxins that it deposits into the air. Toxins that involuntary smokers have no choice but to inhale, unquote. I would recommend that ABCA delay implementation of the summer garden endorsement for cannabis at the present time. Alternatively, I would recommend that ABCA prohibit the issuance of a summer garden endorsement for cannabis where the summer garden is located adjacent to one or more residential properties, even if these properties are separated by a narrow alley. Third, I would like to respectfully request that the renewal year for cannabis retailers not fall on the same year as the renewals for restaurants and tavern licenses. As chair, I've managed the renewal process for ANC6B through 2 cycles with over 50 restaurants and tavern licenses. It always creates a tremendous amount of work for commissioners, and I suspect for ABCA staff and ABRA board members as well. Adding the renewal of cannabis establishments to the same renewal schedule as restaurants and taverns is, in my opinion, self-inflicted insanity. Finally, the application process as described by ABCA is unfair and may result in a chaotic scramble for retailer applicants. At a recent training on the proposed rulemaking, ABCA announced that applications for retailer cannabis license would open on November 1st, and that licensees would be approved on a first-come, first-served basis. This Hunger Games approach would disenfranchise longer operating cannabis businesses and result in applicants competing for line placement by camping outside of the Reeve Center on October 31st in order to get ahead of other retailers within 400 feet of their store. ABCA should consider implementing a more organized approach that supports retailers who've been operating quietly in an area for multiple years. By giving longtime retailers with the first opportunity to become licensed would be a more equitable approach and less disruptive to current customers. In the worst case scenario, a well-established retailer could see their business shuttered and their investment lost because of their place in line. On a related note, the regulations state that 50% of all retail licenses would be issued to equity applicants. Put another way, the number of total retailer licenses would be capped at twice the number of equity licenses and then increase on a one-for-one basis. So if 100 equity applicants are approved, then the maximum number of total licenses would be capped at 200 and then only increase when another equity application is approved. I asked a rhetorical question of whether this is what the law and ABCA intended. Surely ABCA did not intend for unlicensed retailers to continue operating with the threat of being shut down until additional equity licensees enter the market.
So I need to wrap
Again,
up.
I would like to thank you for the ABC board for holding this public hearing, and I would be pleased to answer any questions you may have.
All right, thank you, sir. Mr. Adams, let me see where.
Can you hear me all?
Yes, I can hear you, sir. Go ahead.
Great.
Sir.
Thank you for your patience here. Good morning, everyone. I'm Zach Adams, ZACHADAMS, ANC for 2B08. And much like Commissioner Ruckauer, I'm here on behalf of myself and my SMD, not on behalf of ANC 2B. I cover a chunk of North DuPont Circle and the west end of U Street. I'd like to thank ABCA for taking the time to have this meeting and hear stakeholders, including ANCs, and for thoughtfully engaging in this cannabis license rulemaking process. I'm making 3 short asks here. I ask for further harmonization of cannabis licensure requirements, in particular the distance requirements between cannabis locations and schools and between each other. These licensure requirements, should they cause legislative burden on ANCs who need to keep them all straight when negotiating settlement agreements and informing their constituents. I ask for there to be an established submission period for applications so that it's not first past the post, and that the speed at which applications are submitted does not give an advantage to any applicant looking for a license. I think this will only result in frustration as businesses are subject to the whims of the online portal or mail service. For those of you who participated in the vaccination lottery in DC or have participated in a sneaker drop, you may empathize with this. And someone participating may give up trying to submit or feel like the system is unfair if this is not met. I also, lastly, ask that criminal background checks are eliminated fully from applications, not just for the social equity applications, as I believe that they are inconsistent with the social equity lens of the new licensing process. That's it from me. Thank you all very much, and I'm here for questions.
All right, thank you, sir. Any questions by any board members of any of the 3? I'm sorry, of any of the person who testified. Any questions by any board members? I don't have any questions at this moment, but I will remind all parties to please send us a copy of their written testimony to abca.legal@dc.gov, and the comment period will remain open until 30-day period. Yeah, the 30-day period to continue. Yeah, I don't have any questions for any of the parties. Just because since the board wasn't privy to your questions, that we couldn't formulate any questions to ask. But I know someone talked about the location and who's going to do the measurement. ABCA will provide the measurement to all the parties. So the same for alcohol, we're the one who would provide the measurement with the distance. So that's something that is taken care of. And I know Mr. Jamarin, you talked about the 8 ounces. I think so far you're in the minority, because we have gotten many submissions by patients and others regarding the 8-ounce limitation. So the board will be looking at that. But your visual, at least for me, made sense, because I've never seen 8 ounces myself. So, but thank you for the visual. All right. So I want to thank you for your presentation today. And I said before, you're welcome to submit your written comments to abca.legal.dc.gov. Thank you very much. All right. All right. So let me call the second panel. All right. Thank you. So the second panel that I'm going to call now is that I'm going to call. So I'm asking Mr. Oriana to please elevate Hannah Clark, Meredith Kinner, John McGovern. Those 3 people, I'm asking that they be elevated, please.
One second.
Thank you.
Apologies, Chairman. Can you repeat that list one more time?
The last person would be, I'm sorry, John McGovern. The Meredith Kinner and John McGovern from the Kinner and McGovern group, and Hannah Clark from the I-71 committee.
For some reason, I can't elevate Hannah Clark.
Hannah Clark.
One sec. There we go.
All right, thank you. All right, everyone. So let's start with Hannah Clark. I would like everyone to turn the camera on if they have that ability. All right, good morning, everyone. So let's start with you, Ms. Clark. So please, can you please identify yourself for the record, and you have 5 minutes, please. I can't hear you, ma'am.
Fantastic. Good morning. Hi, can you hear me now?
Yes, ma'am. Yes.
All right, I'm Hannah Clark. I'm the Executive Director of the I-71 Committee. Do you need me to spell my name?
Yes, ma'am, please.
Yes, sir. HANNAHCLARKE. Thank you for the attention today. I'm going to head into my testimony. I want to give first thanks to the ABCA board staff and other attendees of today's public hearing. I am the Executive Director of the I-71 Committee. The I-71 Committee is a coalition of citizens, industry leaders, and stakeholders who are committed to passing equitable, fair, and socially conscious cannabis legislation. We prioritize safe and equitable access for all. We are excited for the future of the cannabis industry in DC and are eager to join the pioneers in a regulated market. We're a diverse industry reflective of the fabric of this great city, employing people of color, women, veterans, disabled, and LGBTQ identifying people. The I-71 committee has 24 due-paying members who employ DC residents, pay DC taxes, host and support charitable events, and make contributions to local nonprofit organizations. While ensuring that the members of our committee operate at the highest standards and provide safe and quality cannabis products, the I-71 committee is working to ensure DC, like every jurisdiction, has the ability to make its own decisions around cannabis access and regulation without interference from the U.S. Congress. The I-71 committee is thankful to the ABCA board, its staff, the DC Council, and the mayor for their collective efforts to create a more equitable and high-functioning cannabis industry. We believe that the proposed regulations are a massive step in the right direction. However, we do share some concerns. Firstly, it is evident that there are not enough supply and cultivation in Washington, D.C. support to meet the demand that accounts for the total market value. The current infrastructure lacks the capacity to meet the demand for cannabis products. We have been in communication with licensed medical operators who agree and echo the same concern. This shortage poses a challenge for both existing and potential retailers, as they would struggle to source sufficient cannabis to satisfy consumer needs. By postponing retail licenses, we can allow for cultivation operations to expand and fulfill the market demand adequately. This ensures a consistent and sustainable supply chain for retailers, leading to a healthier overall market. The second is business-friendly regulatory environment would be crucial for the success and longevity of the cannabis market in Washington, D.C. To foster an environment that encourages entrepreneurship, innovation, and investment, regulations must strike a balance between compliance and flexibility. It is the committee's opinion that this legislative body should postpone retail licenses so policymakers can reassess, refine existing regulations to ensure they are conducive to business growth and market development. By postponing retail licenses, policymakers can carefully evaluate the equity landscape and implement measures to support and empower existing operators. This may include targeted programs, resources, partnerships aimed at providing technical assistance, access to capital, and other support services necessary for their success. Prioritizing equity not only fosters social justice, but also enriches the diversity and inclusivity of the cannabis market. In conclusion, I urge this committee to support the postponement of cannabis retail licenses in Washington, D.C. By doing so, we can address the current supply and cultivation limitations, foster a business-friendly regulatory environment, prioritize equity and social equity for existing operators, and develop regulations based on unique market indicators. Delaying licensure for retail businesses allows for a more comprehensive evaluation of the market dynamics and consumer preferences. The cannabis industry is rapidly evolving, and it is essential to gather the data and insights from existing retail establishments before introducing new players into the market. By observing and analyzing the performance of current retail businesses, we can better understand the demand patterns, market saturation, and potential areas for growth. This approach enables policymakers to make informed decisions, objective decisions that foster a healthy and competitive marketplace. Thank you.
Thank you, Ms. Clark.
Of course.
Ms. Kinner, can you identify yourself for the record, please?
Yes. Thank you. I'm actually Meredith Kinner. I am an attorney at Kinner and McGowan, and actually my colleague John McGowan is going to be speaking on behalf of our firm.
All right, fine. Go ahead, Mr. McGowan. Can you please identify yourself for the record, please?
Yes, good morning. My name is John McGowan. I'm a attorney in DC with Kinner and McGowan. May I begin testimony?
Sure, go ahead, sir. And I'll give you some more time since I had both of you separately. So go ahead.
Thank you so much. Yeah, thank you for the opportunity to testify today on the medical cannabis emergency and proposed rulemaking. We're submitting this comment on behalf of our clients and other industry stakeholders that plan to apply for medical cannabis licenses with ABCA throughout the year in 2023. Our law firm, Kinner McGowan, was established in the district in 2015 with a primary practice area focused on cannabis law. Since inception, we have witnessed the evolution of the gray market firsthand, from pop-up shops to brick and mortars and e-commerce delivery companies. In our 8 years of practice, we've had the opportunity to counsel with a significant number of unlicensed operators, i.e. I-71 operators, and also other ancillary stakeholders in the district's gray market. We believe this experience gives us a unique perspective on this issue and insight on how ABCA can amend the proposed rules to make DC's medical cannabis market practically more inclusive. We do commend ABCA for envisioning an expanded program that promotes social equity and provides some kind of mechanism for eligible unregulated operators to actually become licensees in the district. However, as currently drafted, The proposed rules will significantly limit the number of social equity applicants that will actually be able to apply and qualify, and it fails to provide an actual pathway to licensure for the majority of otherwise qualified unlicensed operators that will be applying. Now, we do recognize that the ABC Board's authority is regulatory, not statutory, and that amending the DC Code provisions are in the purview of the council. However, ABCA is ultimately responsible for the administration of the program and does have the authority to amend the proposed rules to account for certain problems created by the statutory language. The following comments are intended to propose a variety of ways ABCA could amend the proposed rules to make the regulated cannabis market more inclusive for all applicants, including unlicensed operator applicants. First, the criteria for determining an applicant's social equity status is far too narrow and should be expanded to be more inclusive. Social equity status is key to becoming licensed this year because social equity licenses are definitively uncapped. As such, the criteria for social equity should be expanded to include more prongs and encompass more social equity applicants. The definition of social equity as proposed in the rules represents a drastic departure from social equity measures that have been implemented in other jurisdictions. The goal of an effective social equity program in the context of cannabis, medical cannabis, must be inclusion, must create opportunities for individuals impacted by the criminalization of cannabis to enter the legal cannabis market as beneficial owners. More broadly, social equity programs are intended to create pathways for economically disadvantaged communities to benefit from legalized cannabis through employment quotas for all licensees and community reinvestment initiatives. These dual social equity goals are accomplished by focusing the criteria both on applicant ownership as well as applicant employees and contractors. Second, if ABCA does not expand the social equity criteria, then it should amend the criteria to allow applicants to satisfy one prong instead of two in order to qualify for social equity status. The proposed rules require an applicant to satisfy two or more of the social equity criteria proposed. Amending the rule to require an applicant to satisfy only one or more of the criteria would increase the number of applicants that would be able to actually qualify for social equity status. A one-prong approach also would in turn have a trickle-down effect across the entire spectrum of applicants in all subsequent open application periods. Specifically, it would affect non-social equity applicants because the number of non-social equity licenses that ABCA can award, including unlicensed operators, is contingent on the number of social equity licenses that have already been awarded. It stands to reason that if an applicant can satisfy one of the three prongs for social equity, they should reasonably satisfy any social equity applicant standard that the council envisioned. Further, the one-prong approach will not diminish the council's intention of promoting a fair and equitable program. Third, the 50% social equity set aside should not be applied to unlicensed operators in the November 1st, 2023 open application period. The proposed rules apply the set aside to all licensees. However, this should not be applied to the unlicensed operators, or the rules should be amended to apply the social equity set aside specifically to applicants that apply in the 2024 non-social equity application period. By limiting the 50% social equity set aside to future applicants only, ABCA could satisfy the statutory requirement for the set aside while still offering an uncapped number of licenses to qualifying unlicensed operators, as it has been suggesting throughout its guidance. The extremely restrictive criteria for social equity, coupled with the 50% set aside, will, practically speaking, when this all plays out, prevent the majority of unlicensed operators from transitioning to the medical cannabis market. Denying these operators that otherwise meet the statutory qualifications for a license will have ramifications, frankly, on the viability of the program based on supply and demand issues, and undermine the council's goal of transitioning good faith business owners from the gray to the regulated market. Another issue with this is there is no way to determine the number of licenses that will be set aside or available for unlicensed operator applicants during the November 1st period until after the application period has passed. This is because ABCA is not offering social equity retail licenses until 2024, but it's offering retail licenses for unlicensed operators in 2023. This disconnect is going to create a situation where applicants for unlicensed operator licenses that otherwise, meet all the statutory and regulatory requirements for licensure will be left waiting for an indefinite time period for ABCA to determine if it can license non-social equity applicants during the actual period. Many applicants, while they're waiting, will likely be incurring significant expenses, such as paying rent for commercial property and also the $8,000 non-refundable application fee, while waiting for ABCA to determine the set-aside limits on licenses. This could also, by capping the number of unlicensed operators, by applying the set-aside to them, could also lead to unintended consequences for the program. This means effectively that the unlicensed operators' licenses will be capped. And this critical fact conflicts with multiple representations made by ABCA that licenses are uncapped for unlicensed operators. ABCA has provided guidance for unlicensed operators, which suggests that applications submitted during the application period will be reviewed on a rolling basis. However, practically speaking, as I just mentioned, there will be no way, as the proposed rules suggest as now, for ABCA to process applications on a rolling basis while also having to wait until the next application process to determine what the license cap is. It may just be like, we accept your application, now you're in a holding pattern until we figure out what the numbers are until next year. The practical implications of ABCA inviting qualified unlicensed operators to transition to the regulated market only to deny the majority of these operators the opportunity to enter the market are significant and will disrupt several small business owners in the district. This was not what the council intended. There's a popular perception we have heard among unlicensed operators that the council's effort to license and regulate the gray market is really a de facto Venus flytrap, right? It's designed to lure them in to the regulatory ambit only to deny them and eviscerate their livelihood and the real opportunity to become licensed. Or worse, not actually having a license for them to actually obtain. This perception is not unfounded. ABCA has repeatedly represented that similar to liquor licenses, licenses for unlicensed operators will be non-competitive and uncapped. But the notion of an uncapped number of licenses also ostensibly eliminates the significant financial risk associated with a glut of applicants applying for a very limited number of licenses. Finally, the 50% social equity set aside is also problematic because it does not account for a scenario where there are no social equity applicants that apply in one or more categories. For instance, there is currently an application timeline going on time period now. If there are no social equity applicants that apply in the current social equity application window from May 1st to June 29, 2023, there will be no new cultivator and manufacturer licenses available for the general public, making the open licensing application period for non-social equity manufacturer and cultivation licenses that are going to be available to the public in August effectively moot because there will be zero available.
All right, Mr. McGowan, thank you very much for your testimony today, sir. I remind you that you have until June 21st to submit comments, your written comments to apca.legal.dc.gov. All right.
Thank you for your time.
All right, sir. Thank you. Any questions? Any questions, planning board members of any of the witnesses who testified this morning?
Mr. Chairman?
Yes, Mr. Grandis, go ahead.
Thank you. Mr. McGowan? Thank you for taking time out of your work schedule to provide testimony and written testimony today. We appreciate the guidance that the public can give us, so thank you for that. In reading your testimony, I may be confused, and that's easy because this is a subject that we all are learning and working on together. But is it the law firm's perspective that one of the ways to be considered a social equity applicant is that they've had a conviction? And if they did not have a conviction, they would not be eligible under the program we're trying to establish?
I can actually speak to that, if that would be okay, Mr. Grandis. So the proposed rules say that to qualify for the second prong of the social equity criteria, so that's the qualifying family member prong, that family member has to have been incarcerated due to a conviction. And we corresponded with ABCA's general counsel about this, and they confirmed that yes, in fact, that qualifying family member, they have to have been incarcerated due to a conviction. It cannot be because they were in jail overnight. It cannot be because they were in jail leading up to trial, which was eventually dismissed. It has to be due to a conviction. Does that answer your question?
Yeah. Ms. Kiner, am I saying your name close enough? Ms.
I'm
Kiner, is
sorry,
that
I
correct?
can't hear you.
You're on mute.
Okay, Ms. Kiner,
Oh, I'm sorry, I couldn't hear you. Can you say that again?
can you hear me now?
Yes, I
Can you hear
can.
me?
My fault. I'm very sorry.
No, that's cool. So your last name is Kiner. I hope I'm pronouncing it somewhat
Kinner.
correct.
Kinner, yes, Meredith Kinner.
Okay, thank you for your perspective. We will look into that, to the understanding you have, to make sure that what is intended to be in the statutory and regulatory provisions accurately match what the law that was adopted says. So thank you for pointing that out. Let me ask, in either one of you, have you counseled your clients who I think you say would fall under the current I-71 provision, that after that provision sunsets, that they could no longer be for sale or gifting cannabis?
Oh, yes.
And your firm is supportive of that requirement?
Yes, I mean, I think if there is a good faith attempt, and there is a good faith effort, more than attempt, if there is a good faith effort, as John stated in our comment, to actually allow these businesses an opportunity to transition, then I think if they're given a fair opportunity, they need to comply with the law once that safe harbor provision sunsets. We've counseled our clients to that effect.
This is what the government is trying to do, is handle a privilege, not a right.
Of course.
Correct?
Right. No, of course. It's just if they otherwise meet statutory qualifications, and it's the social equity set aside that's preventing them from becoming licensed, that is what we think could create a problem. I mean, we're referring to, when I'm speaking of people who can go through that and become licensed, I'm speaking of otherwise qualified I-71 applicants.
So Ms. Kiner, this is theoretical, so it's possible that there may be a disagreement, if I could use that concept, between what the government's trying to do, which is to regulate and not have the Wild West. There could be a situation where you all would advise your clients to go back to counsel to extend. This is hypothetical, because quite frankly, it has been a concern with our legal market and how to make sure our legal market is successful. Okay, so just know that we appreciate the fact that you are counseling your clients, that there is a sunset on this at this time. Ms. Clark? Hello, Ms. Clark, can you hear me?
I can hear you just fine. Yes, hello.
Yeah. Are you a resident of DC?
As of 2023, I am in Arlington County. As for the last 3 years, I've been in Ward 2.
And I think you mentioned in your testimony something about taxes. I think you said that, if I understood, that you are an executive director of an entity called the I-71 Committee.
Yes.
So how has taxes been determined? How do you determine taxes?
Sales
You're
taxes,
saying,
business taxes.
I'm sorry?
There are sales tax, business tax, payroll tax. A lot of these I-71 businesses who are trying to be as compliant as possible to prepare themselves into this regulated market, they have documentation like certificate of clean hands or certificate of good standing. So they don't owe the district more than $100. They
But the tax, what is it based on? I understand that a number of these retailers are gifting and not selling.
So part of the gifting process is to have tangible goods and services. So those technically are what sales tax is being applied to.
Okay, thank you. And do you know, is part of being a member of this 171 committee that's a retailer, do they test their products that they are gifting or selling?
There are avenues in which specific retailers have the ability to test, but the district does not have a protocol for these stores at the moment, although we're continually working to create some sort of collaboration between future licensed businesses and opening new testing facilities.
And are your members prepared to shut down if they do not qualify for a license under the current provisions for either social equity or the other licensing opportunities within this 300 and so many days? Are they prepared to stop gifting or selling cannabis products?
The understanding of the committee is that once they either are approved for a conditional license or approved for a retailer, internet retailer, cultivation manufacturer license, there's a period of time where they will have to shutter operations. On top of that, they also understand that there is a sunset period within that safety harbor.
And your committee understands that once they are licensed, that they have to purchase the cannabis products from our cultivating centers?
Yes, they are. And actually, one of our largest focuses is on providing support for the current cultivation facilities in the district, either expanding their current operating processes or focusing primarily on adding new cultivation licenses, new manufacturing licenses, which will bring more supply to the I-71 demand that they've been shouldering for the last 8-10 years.
Ms. Clark, I want to thank you, and I want to thank the law firm for the time of answering my concerns. I want to thank you all very much. Thank you, Mr. Chairman.
Thank you, Mr. Chairman.
Thank you.
Thank you. All right. Thank you very much. Thank everyone for their participation this morning. I just want to remind you that you can send your written testimony to abca.legal@dc.gov. You have until June 21st to send comments for this hearing, or you can, once the regulations are published, you have 30 days after to do that. So thank you very much for your presentation this morning. So let me call the next set of witnesses. So I'm calling, so Mr. Oriana, can you please elevate Anton Pritchett Sr., Anton Pritchett II, Rabbi James Kahn, Rabbi Jeffrey Kahn, Stephanie Kahn, and Joshua Kahn. Can you please elevate them, please?
Sure, 1 second. Apologies, Chairman. Was the last person Donald Temple?
No, I'm not calling him in this panel.
Okay.
Joshua Kahn is the last person. So everyone from Tacoma Wellness and from Renee and Andrea Health, yes.
Okay, they should be elevated.
There should be another Antoine Pritchett Sr. that should have been elevated. I'm the second.
Right. Yes, I did call Antoine Pritchett Sr. and Antoine Pritchett II.
Thank you, Mr. Chairman.
So do we have everyone here now? All right, so let me start. Sorry. So good morning, everyone. So let me start with Mr. Antoine Pritchett Sr. Good morning, sir. Good to see you again.
Good morning.
So
Good
please,
morning.
you can please start by spelling and stating your name. I'm going with. I'm sorry. Let me see. I'm going on the list, so therefore I'm gonna go with. Oh, I'm going with Mr. Pritchett Sr. All right, so I guess that's the person who's about to speak. Good morning.
Good morning, sir.
Go ahead, Mr. Pritchett Sr. can start, please.
Good morning, sir. How are you?
I'm well, thanks. Go ahead. You have 5 minutes, sir.
Thank you. Good morning to the wonderful members of the board and my fellow stakeholders this morning, willing to listen to a person who has a little experience in the regulated market. My name is Antoine Pritchett Sr., and I hope to one day soon be able to help my son and his business partners launch Renee and Andrea Health in DC as the COO. I will not bore you with credentials, but simply say that I've been there, done that, and got the t-shirt in DC and Maryland. What I would like to speak about are parts of the legislation as it currently exists and some things that are not in there but could be. Most importantly, I want to talk about how the legislators, the regulators, and the operators can work together to make the DC cannabis market the bellwether for the country. Teamwork makes the dream work. When it comes to a regulated market like cannabis, that could not be any truer. The market is comprised of legislators, regulators, and operators. So much of what makes a market successful is the cooperation amongst all the oars on the ship that is regulated cannabis. It was originally tossed around that there would be an advisory board that would include industry experts, industry operators, regulators, and legislators. I would like to recommend that we put a panel together to talk about what makes sense and what doesn't make sense with operator input. For instance, if a batch fails testing, which is covered by Section 6600, then there are no methods of recourse or remediation. No one is perfect, including testing labs and cultivators, so there should be a method of retest remediation. By not including language that allows for retest or remediation, you might be dooming smaller growers who don't have the volume of flowers to withstand the loss of an entire harvest. Considering that cannabis businesses, as they stand right now, do not have bankruptcy protection, this could spell the end for a smaller grower, like a social equity applicant. Allowing for retest and remediation through processing would enable a cultivator to, at the very least, recoup some of the expenses of growing that harvest. Since adulterated was specifically spelled out in the legislation, how it can be retested and remediated needs to be spelled out as well, or simply remove the words unfit for use and then spell out acceptable remediation methods. The specifics of how and why this is something that an advisory panel would tackle. A social equity advisory board would work with current social equity applicants to figure out what their hurdles are so that with each iteration or amendment to the program, it gets even stronger. And an advisory panel would help to drive this. This will give legislators and regulators an opportunity to hear the points of pain when standing a cannabis business up from a social equity perspective. Of course, the most crucial of which being raising capital. Unlike other businesses that have access to traditional lending sources, most cannabis businesses are launched by trading equity for capital. Unfortunately, there is nothing in the bill that makes sure to take this issue into account when helping social equity applicants to be successful and still lawful. As the program moves forward, this needs to be addressed, and my hope is that there will be some emergency legislation to account for capitalization and how it can be accomplished in the current legal framework for a cannabis business. Maybe an amendment that deals with the capitalization hurdle. Bringing all the oars together with an advisory board to better inform policy should be something that DC would be looking to be the bellwether for. Creating a social equity board to flesh out the details for social equity applicants and best practices to help them be successful. Enacting legislation that accounts for the way a cannabis business is capitalized will help to better set a social equity applicant up for success. Creating regulations that protect the public and promote good business practices can only be accomplished by rowing the regulated cannabis boats with all the oars working together. Hearing from operators help to inform what regulations do and how they affect their business. By working together with operators, a regulator becomes someone that the operator looks to for guidance. But without the input of operators, some regulations don't provide for safe or a better product, just creates an additional cost for doing business. I would ask as we move forward, there's more communication with the current operators, the current licensees, and that we concentrate on rowing the cannabis ship in the right direction. So much is riding on the success of this program, and we all owe our very best efforts and voices to ensuring that DC is poised for a market explosion and market evolution. And I would recommend that we get the oars together in the form of advisory boards, so we row DC cannabis boat towards success instead of possibly rowing in a circle. I would like to thank the board for their time and consideration this morning, and look forward to helping row DC towards being the bellwether for cannabis in this country.
Thank you, Mr. Pritchett Sr.
Thank you, sir.
All right, Mr. Pritchett II. Go ahead, sir.
All right, good morning, Chairperson, as well as to the ABC board and my fellow cannabis stakeholders. I want to thank you. My name is Antione, Pritchett. Suffix is Roman numeral 2, and I am the CEO of Renee and Andrea Health, the first medical cannabis CBE to be approved for a license in Washington, D.C. We believe that the newest regulations are a step in the right direction, but as we've already submitted written comments to ABCA and Antoine Sr. has touched on a few of our concerns, I'd like to shift the discussion with my testimony today. It is my professional opinion that the shortcomings of the emergency regulations are merely symptomatic of the root cause of our current objections, as well as the source of many of the challenges we face, not just in the district, but in the industry as a whole. The lack of adequate, proactive, and clear communication and collaboration between those who regulate the businesses and those who run them. So often in this industry, policy is enacted without consulting subject matter experts on how to best accomplish the goal of effective regulation, and the industry professionals, business owners, and the public are left to deal with the fallout. The role of government in a capitalist economy, as defined by the International Monetary Fund, is to maintain an orderly environment that facilitates proper functioning of markets. And for a government to accomplish this objective, it requires they meet industry in the middle, establishing open channels of communication between the regulators and the regulated. This is why every other industry in the United States has a seat at the table when policy is being made. Yet somehow, despite the unparalleled overregulation, taxation, and complexity of the cannabis industry, we are still the only industry that does not have a seat at that table. These newest emergency regulations are only one example of the many symptoms of the regulatory dysfunction that currently plagues our industry throughout the country. Every other state has taken the same anti-business approach to regulating cannabis, and it has backfired each time, largely to the detriment of social equity operators like myself. The smaller the operator, the larger the risks associated with operating a cannabis business, and I think the board would agree that inadvertently erecting additional barriers to success is neither the goal nor the function of government. The only benefactors of poorly crafted regulations are those with the resources and money to withstand the unnecessarily elevated costs of doing business, in other words, multi-state operators. The more we are regulated without making social equity licensees a meaningful part of the conversation, the more regulators will contribute to the shuttering of those social equity businesses and the thriving of corporate giants and conglomerates whose chief goal is to eliminate competition. You'd be essentially doing their job for them while harming the people you claim to champion, and no one wants that. So let me be clear, I'm not here to lambast ABCA or the board, but to illustrate the gravity of this unprecedented opportunity, which will not come again. We will not have another chance to develop this market, and if done improperly, the consequences will be dire for many vulnerable people. With the district's cannabis market entering a new phase of development under ABCA, it requires that we adopt a new approach to how we accomplish our common goals. Those goals being to establish and grow a stable medical cannabis market, which provides patients with safe, high-quality medicine and ample choice, to provide real opportunities for social equity applicants in the district to create generational wealth and to help undo the damage done by the war on drugs, and to make Washington, D.C. the international benchmark for what a cannabis market and a social equity program can be when regulation is rolled out and executed properly. I can tell you that in the absence of meaningful conversation, the stated goals of the board will be undermined, and the outcome of the DC medical cannabis market will likely echo that of other more developed markets, where social equity businesses will largely fail, and without bankruptcy protection, people's lives will be destroyed, and the only ones left standing at the end will be profiteering multi-state operators. Therefore, I implore any and everyone at the DC Council, ABCA, the board, DSLBD, and all other governmental stakeholders to speak with myself and other industry experts on how to avert this crisis and take a stand for the values which we all espouse: diversity, equity, and inclusion. Let us work together to create what we all envision for Washington, D.C. and its residents: a thriving medical cannabis market which provides patients with consistent relief and Black and brown entrepreneurs in our nation's capital with unprecedented opportunity. To accomplish an unprecedented goal, unprecedented measures are necessary, and to that aim, my recommendation to facilitate this meaningful conversation is to create a Social Equity Advisory Commission, as Antoine Sr. alluded to, chaired by stakeholders such as subject matter experts, social equity business owners, and members of the public. I am open to any and all dialogue necessary to realize this recommendation and welcome all collaborators who share the same values and goals. Thank you for your time.
Thank you, Mr. Pritchett II. All right, so let's have Rabbi James Kahn.
Thank you. Chairman Anderson.
Good morning, good afternoon, sir. Go ahead.
Good afternoon, Chairman Anderson and distinguished board members. My name is Rabbi James Kahn, and in 2013, my family opened Tacoma Wellness Center, a DC-owned, independent, mom-and-pop medical cannabis dispensary, which is now home to more than 55 full-time staff members, mostly DC residents. As you know, the cannabis industry is facing immense challenges. Onerous tax laws, banking restrictions, cumbersome regulations have all combined, along with an oversaturation of licenses and unchecked competition from the legacy market, and it's proven too much, even for big businesses. A recent report by Whitney Economics studied more than 400 licensed dispensaries around the country. Only 26% had turned a profit in 2022. This is not sustainable, especially for small businesses. To make matters worse, cannabis entrepreneurs cannot access traditional sources of capital, making it difficult to weather even normal market downturns and leaving us vulnerable to predatory lending practices. And as Antoine Sr. mentioned, we also lack the protection afforded by federal bankruptcy laws, leaving too many struggling business owners, especially those social equity applicants and license holders, saddled with the nightmare of generational debt, not the dream of generational wealth. Far too many have been and will continue to be forced to sell as distressed assets, purchased by one of a handful of uber wealthy corporations destined to monopolize our industry, companies with pockets deep enough to endure cannabis's slim margins and immense tax obligations, capable of riding out the storm. Now, I'm not here to depress, but to highlight the power of regulations, to highlight your power as regulators. Over the past decade, I've watched as the district's cannabis regulations have evolved in ways that have strengthened DC's cannabis license holders. First by allowing reciprocity with other states, then by increasing purchase allotments, and finally through self-certification. You have allotted new licenses only when demand existed and when supply was in place. These actions have allowed DC's cannabis market to endure, even in the face of a lot of challenges, and have kept DC's original group of cannabis license holders, one of the most diverse in the nation, in control of their businesses, and largely have kept large multi-state operators out. Unfortunately, many of those regulatory protections are set to disappear. The Medical Cannabis Act of 2022 puts an end to DC's license caps, opening the door to market saturation, price compression, and further divvying up an already small market. Maryland's adult use program will make the situation even more challenging, offering our customers access to cannabis without forms or fees. To continue to thrive, DC once again needs your help. It needs its regulators to help bolster our industry, not to diminish it. One such regulation already exists: the expansion of ABCA's non-resident visitor passes to include both short and long-term options at discounted rates. However, ABCA's decision to wait to institute that change until October 1st is a missed opportunity with real-world implications. We have seen patients reluctant to purchase monthly passes, knowing more economic options are coming in October. And patients that do purchase them must be convinced to do so again every 30 days. This is no easy feat with so much competition surrounding us. In short, this decision is costing stores critical income and costing DC lost tax revenue. Please reconsider this and allow us to implement that change as soon as possible. And please consider the other changes that will be requested by my colleagues today. Let's not wait for DC's program to decline and for businesses to close or to be sold to large operators before we act. I am proud of the district's program, and I want to thank you for all you've done to make that the case. Thank you.
Thank you, sir. So we'll have Rabbi Jeffrey Kahn speak. Rabbi Kahn, Jeffrey Kahn.
Yes, good afternoon, Chairman Anderson and members of the ABCA board. I am Rabbi Jeffrey Kahn, a Ward 4 resident and business owner. My family and I founded DC's very first medical cannabis dispensary, Tacoma Wellness Center, in 2013, after our participating in the application process from 2011. We're now celebrating our 10th anniversary of serving the public. Today, I want to call your attention to language in Section 301.1 of the regulations. The maximum amount of medical cannabis concentrates a qualifying patient or caregiver may possess or purchase within a 30-day period, which will be reduced from 8 ounces to 8 grams. There are several reasons why some medical cannabis consumers may require high-dose cannabis products to achieve significant benefits, as much as 8 ounces a month. Medical conditions. Certain medical conditions require higher doses of cannabis to effectively manage symptoms. For example, patients with severe chronic pain, multiple sclerosis, cancer-related pain may find that lower doses are insufficient. Tolerance development. Frequent cannabis consumers develop a tolerance over time, requiring higher doses to achieve the desired effect. Individual psychology. Every person's psychology is unique. Physiology is unique, and some individuals may require higher doses to experience the desired therapeutic effects. Treatment resistance. In some cases, individuals may not respond adequately to lower doses. This can occur with certain medical conditions, such as epilepsy or severe nausea associated with chemotherapy, and cost and convenience. For individuals who consume cannabis regularly, using high-dose products can be more cost-effective and convenient. Higher potency means smaller amounts are needed, reducing overall consumption and cost in the long run. This can be particularly beneficial for patients who rely on cannabis for which there is no insurance or any other kind of financial reimbursement. Since 2015, we have worked really closely with Council, our regulators, both at the Department of Health and ADRA and now ABCA, to increase the amount of concentrates available to 8 ounces per month. That amount now meets the needs of our patients. We don't have any issues. Please don't force our patients to the unregulated, untested market to get the meds they need now and we now supply. We fixed this problem once. Please don't take away the right of DC's sickest patients from legally purchasing the medicine they need. Thanks so much.
Thank you, Rabbi Kahn. So we'll have Stephanie Kahn.
Very much.
I can't hear you, ma'am.
Sorry.
Okay, go ahead now, ma'am.
Thank you. Good afternoon, Chairperson Anderson and distinguished board members. I'm Stephanie Kahn, and as you've heard, my family and I have owned and operated Tacoma Wellness Center for the past 10 years. I will be addressing one of the concerns we have with the current practice. I spend many hours a week helping patients navigate DC's medical cannabis program. And I see the barriers to patient access that continue, despite the many improvements that ABCA has made. Too often, patients are unable to contact ABCA to work out problems because the office is closed, even though the dispensaries are open. We certainly do not expect you to work the same hours as dispensaries, but it is vital to have a workaround to allow patients who have difficulties obtaining a registration or self-certification to obtain their medication without waiting 24 to 72 hours until your office is open. We request that either ABCA provide us with a list of numbers that can be allocated to these patients, or that we can use their driver's license numbers as their patient ID number, as many other states do now. Allowing a workaround for medical cannabis would address this issue by enabling patients to obtain their medication in situations where they would otherwise be unable to do so. During this last quarter, we have had 50 patients come to us after applying for either a self-certification or a non-resident visitor pass and received neither a registration nor a payment link. These individuals did not know if their application had been received or if they had made errors. They had no idea that if they had made errors, what those errors were or how to fix them, other than to submit another application, which is discouraged on the ABCA website. Many of the patients had tried to contact ABCA on their own, but did not receive a response. We contact ABCA on their behalf. However, 30% of these problems come after working hours or during weekends and holidays. In the current climate of hundreds of illicit dispensaries, and soon with Maryland opening a recreational program on July 1st, these patients can easily choose to go to a dispensary without restrictions, limitations, or charges. We have asked numerous times for a workaround, but none has been granted. Many of the patients currently leave and go elsewhere now, and more will do so once Maryland opens up. This currently affects patient satisfaction. Our patients blame us, and we have received numerous bad reviews regarding this practice, and will soon severely impact all of the licensed businesses. ABCA has worked tirelessly to ensure the DC Medical Cannabis Program is a success, and we know that is your goal. Please provide us with either a list of patient numbers to be allocated or allow us to use driver's license numbers as a workaround so that we don't continue to lose patients due to glitches in the certification process. Thank you very much for your time, your work, and your consideration.
Thank you, Ms. Khan. Mrs. Khan. And Joshua Khan.
Hi, I'm Joshua Khan, co-owner and operator of Tacoma Wellness Center. I'm here to express our strong opposition to the proposed limitation on patient concentrate purchases in our medical cannabis program. Concentrates such as oils, tinctures, and edibles offer an alternative method of consumption that can be easier on patients who may have difficulty smoking or vaporizing cannabis flower. Imposing limitations on these products could severely impact their quality of life and push them towards more expensive and less effective pharmaceutical alternatives. For example, many patients battling progressive forms of cancer turn to RSO or Rick Simpson oil. There have been promising reports that attest to RSO's efficacy, such as severely decreasing the leukemic blast cell count in a 14-year-old terminal patient with no toxic side effects, for example. Anecdotally, RSO has helped patients manage conditions such as MS, epilepsy, cancer, insomnia, chronic pain, and asthma, amongst many others. However, the recommended dosing of RSO with those battling progressive forms of cancer is to ingest 20 grams of oil a month over a 3-month period. These regulations would prevent patients from being able to obtain such medicine, limiting them to solely 8 grams of concentrated oil per 30 days. These new regulations would also unnecessarily prevent patients from easily purchasing CBD oils, CBD-dominant vape cartridges, and CBD-dominant concentrates, as it will vastly reduce the amount of flower products they'll be able to purchase. For example, a patient would now only be able to purchase, if these regulations pass, a patient would only be able to purchase 8 1-gram CBD-dominant oil cartridges, which contain only 10 milligrams of THC in each, equaling 80 milligrams within 30 days. or they could purchase 8 ounces of flour that's testing at 33% THC, which would equate close to 74,000 milligrams of THC within 30 days. By restricting concentrate purchases, we may inadvertently force patients to consume larger quantities of less concentrated forms, leading to potential overconsumption and unwanted side effects. Furthermore, patients who are unable to obtain the required dosage from legal channels may go to the illicit market, putting themselves at risk and undermining the entire point of this well-regulated program. The proposed regulations state Colorado's regulations as a blueprint for these changes to our program. However, Colorado limits are 8 grams of concentrates per day, not 30 days, and allows for exemptions for patients that travel far to purchase, which is the majority of our patients as they're out of state. I would like to again emphasize, medical patients in Colorado can purchase 8 grams of concentrates per day, not per 30 days. A Colorado patient can purchase 240 grams of concentrates within a 30-day time period. A DC patient, starting October 3rd, will be able to purchase 8. A Colorado patient can purchase 2 ounces of flour a day, equaling 60 ounces in 30 days. A DC patient, 8 ounces in 30 days. Most importantly, starting July 1st, anyone can legally purchase up to 12 grams of concentrates per visit in Maryland. DC patients, 8 grams in 30 days. Lastly, last month alone, 25% of DC's regulated cannabis revenue came from concentrate sales. Our sales will drop and the ability to attract new patients will be undermined by regulations that seek to fix a problem that does not exist. Please leave the purchase limits alone. Our patients are counting on all of us. And lastly, I also would like to just mention, again, July 1st, anyone will be able to purchase adult use cannabis in Maryland without paying for any sort of visitor pass. They'll be paying a 9% sales tax, only 3% higher than DC's sales tax on medicine. We desperately need an ability to provide visitor passes that are not 30 days, that do not cost $30. We need to be able to capture these patients now before they're able to purchase in Maryland without any sort of fee. We ask that we speed up the time frame of the implementation of these new categories, or at the very least, allow patients that do have a visitor's pass to use that visitor pass until October. So we don't have to beg and plead these patients to still visit our program when they again can just simply go into Maryland with no fee for a visitor's pass. Thank you very much for your time and your consideration.
All right, thank you, sir. I think everyone has testified. As I stated in my opening, the board has heard from the patients and the industry, and we will revisit the 8 ounce. So be assured that that will be revisited as part of the review process. And if the board makes no changes to any other provision in the regulations, there will be a change in that in that specific one. So be rest assured that we have heard we have gotten lots of comments, and we have heard loud and clearly that that is an issue that we should revisit, and we have heard and we will revisit that issue. Yes, Mr. Short.
Mr. Chairman, I concur with your statement wholeheartedly. And I think that I've heard from this panel some very interesting information, and I'm enlightened and encouraged that our board now will be able to make some decisions based on the information we're receiving from these 3 panels today. Thank you very much, Mr. Chair.
All right, thank you, Mr. Short. All right, I have some questions that I believe I want to ask you, Mr. Pritchett. We did receive your written comments, and so there are just some comments, just questions I'd want to ask you. You had indicated that the rules should contain remediation procedures if a product is found to be adulterated. Are there examples of a jurisdiction, whether in the U.S. or abroad, that allows for or has procedures for this? Are you aware of any?
Yes, Chairman. Maryland has specific requirements for retesting. So in Maryland, it lays it out very clearly. Depending on what your failure is for, you are allowed remediation of sorts. There's only one failure that you get no remediation for. The only thing that you do not get any remediation for is salmonella. Everything other than that, what you are allowed to do is, if it fails test the first time, you can retest it. If it fails a second time, then you either have to destroy it or it has to be remediated. Remediation means simply processing that through someone who's a processor, or if you have a processing license yourself, by creating concentrates and things of that nature from that same material.
All right, thank you. Now, another question. If the board allows for testing before the product is in finished form, doesn't this create a gap where the product could be contaminated or adulterated?
That's a good question. But what happens is when the flour goes out for testing, no one enters or touches that sample until we get the results back. And the reason why is if you were to do anything except for keeping in the perfect environment, you could alter it. For example, if you have someone who doesn't practice great hygiene, you could actually have someone who could adulterate that product. That's why it's very important that you have SOPs in place, that no product is ever touched without the proper PPE. Things like that will reduce that possibility, but also when a batch is out for testing, the access to that batch is very limited to the GM and normally the person responsible for the testing.
So, isn't the cultivator or manufacturer, aren't they responsible to ensure that the product is safe at the time of delivery to the consumer or transfer to another licensee?
They are indeed.
So there's another question about IP. So can concerns about IP be handled by contract or specific confidentiality requirements in the regulations for testing labs?
Yes. So one of the things that really makes a difference is depending on what a craft grower would be looking to do. We would consider ourselves a craft grower. So there are very specific things, what we would like to call the secret sauce, in the way that we would actually use it to create our end product. Giving that and making that allowable for anyone to see, like a testing lab or something like that. I wouldn't say that they wouldn't collude with a competitor and pass that information off, but one thing you can agree, Chairman, is more people become successful, people try to look and find out why they're successful. So if that is part of our success, you can believe that that will be something that would be a very sought after item. So us being able to do that and not reveal that portion of it, it makes it safe for us to make sure that nobody's going to be copying what we're doing. And because of how competitive this market is, how you fertigate and what you're going to use can change your end product, which gives you a unique selling proposition, which allows you to be successful in the market.
All right. So you also indicated that you prefer that licenses file nutrient management plans. Nevertheless, DC Code Section 71671.5.05 requires that testing labs to provide a report regarding the presence and concentration of fertilizers or other nutrients. You disagree that such a proposal would likely require a legislative change?
That's correct, because the way it's set up right now, everything residual solvents, mycotoxins, heavy metals, all of that is part of the testing strategy that's laid out in the regulations. So if you were to use something like DDT or another growth regulator, that would show up on your testing, because those are all things that we're going to be certain that you are that are set as parameters for the testing for DC.
This is one of the problems when you guys provide written testimony, and then everyone have an opportunity to read it and then have questions to ask. So
I love it.
But so far you've been on point in responding to some of the the concerns that are some of the questions that at least the agency has regarding some of the recommendations. All right, so you also indicate that leaf tissue sampling is too expensive. I'm sorry?
Leaf tissue samples.
Right, that he said that that's too expensive. However, DC Official Code Section 1671.05 requires a testing lab to provide a report regarding the presence and concentration of fertilizers or other nutrients. Is there an alternative means of complying with this requirement that can be implemented by regulation?
Well, you already have those means in place by having a testing facility that is going to be testing for residual solvents, heavy metals, mycotoxin. Those, and there are a list of banned substances that, of course, would show up with your current testing parameters. You wouldn't have to do anything different. If the board were to look for a reason to create a leaf sample and have people do leaf tissue tests, I would implore the board that if they were doing that, they would be doing that for our benefit to try to eliminate the hop latent viroid, which has struck almost every other market and exists in 90% of the facilities in California. That is something that could hinder the industry as a whole. That is something that I would be all for, but changing it just so you can note the nutrients. A test like that, for example, a hop latent viroid test, those test kits run anywhere from $7 to $8 a test kit. So when you're talking about testing each time with those leaf tissue samples, there's no specific guidance on how many plants are a part of that leaf tissue sample. How many times do you need to do it? Do you need to do it in every single phase? Because of course, in every single phase, the nutrient combination that'll be present in that plant will be different. So earlier on, you're going to have more nitrogen. Later on, you're going to have more phosphorus. So the question would be, what are the parameters? Is it a wide scale? And for me, Chairman, we're getting into those bushes for something that's already taken care of in your normal testing procedure. It just creates another burdensome cost for the business rather than creating product safety for the patient.
All right, so regarding flour, is there a state with a better means of comparing flour's concentrates than other products?
Is there a state that you mean in terms of looking at their total allotments?
No, just comparing. I think comparing the quality of flour concentrates and other products. Is there a state that you're saying would say, okay, if you want to mimic, this is a state you can look at to see what's offered?
So there are several on, and it depends on which particular front you're talking about. But in terms of flour, I can tell you that Massachusetts has one of the most restrictive policies. And what you're having in Massachusetts is you're having the exodus of a lot of the big players just because Massachusetts, they never spoke with the operators. So the requirements that they put in made it a very, very, very narrow scope by which you can be successful. So because of that, a lot of the people who invested millions of dollars are leaving that market simply because it's too hard. On the opposite side, you have California, where it may not be as stout as I think it could be. They're getting much better in how they're applying the rules of regulation for your flour quality. For me, for my money right now, it would be somewhere, if I had to choose one, it would be Colorado. Simply because of the quality of flour they actually produce. I would stay away from Oregon simply because of the adulterated market in Oregon and the fact that they are doing about 500% of what's supposed to be grown for the people in that area. So there are a lot of shortcuts taken because they know that that product is going to end up in the black market. So, Chairman, if I were to say, I would look at Colorado, and I would also look at Maryland, look at some of the testing requirements and features and flour quality requirements they have there.
You also talked about security plans, and you're aware that security plans can be amended at 5415.4. Does this address your concern?
That does.
And there's also a rule that eliminates all plans except for security plans. Would this be sufficient for you?
I'm gonna let the big boss answer that question. I'm the weeds person. I'm into the deep details. The more grand open concept is more junior. So please, sir, please answer that question for him.
Yeah, so could you clarify the question for me, Chairperson?
No, there was this is your comments that the rule eliminates all plans except for security plans. So that's the only plan that you have to have a security plan. So I'm saying, is it sufficient to address your concern?
So I would say no, simply because one of the things that you see, especially in an uncapped market where the process is no longer competitive, is that you find people who may not otherwise be qualified or have the resources to stand the business up, to do it effectively and to serve the patients in that district, or in this district and specifically, become a part of that market, and that runs significant risks, right, to not only to the public but also to themselves as business owners. So I do think that it's imperative that it not just be security plans. I know that you're aware of our application process. It could also contain business plans, architecture plans, right? There are so many different facets of this business that need to be accounted for, and I think I am in favor of lowering barriers to entry, but not of lowering the standard of those entrants. And for me, there needs to be an additional qualification, not just of a security plan, but also of a business plan to be included. And I would also say a cultivation plan, because if you're going to have people who are generating the product that's going to end up in this market, you want to ensure that what they're putting in that product, although there will be independent testing, there are still avenues by which that product can be adulterated. So we want to make sure that we're getting qualified people into the marketplace and not just getting bodies in, because those are two different things. And I think quality matters much more than quantity does. So to answer your question, Chairperson, I think that security plans are necessary, but there should definitely be more required in terms of the plans required when applying.
And all right, so regarding 716.71.03, chapter 716.71.03 limits by law where medical cannabis may be used and does not appear to allow medical use of the licensed facility even for employees. Do you disagree with this reading of the law, or such a change would require a legislative change?
So I'll jump in that one. So most employees that you find within the medical cannabis industry, somewhere between 60 and 80% of the employees are medical cannabis patients themselves. And they have this medication where they're supposed to be able to administer this medication to help keep them in whatever state it may be to allow them to function, not making some kind of allowance for that. That's tantamount to having a child that's at school that has a medical condition, and you're deciding they can't have it because you don't want them to have it while they're at school. We've seen time and time again how that's been overruled, and now cannabis can be administered to children while they are at school. The idea that an adult cannot administer their cannabis while they're at work is something that creates a hindrance, because, as I said, a large portion of participants within the medical cannabis industry are medical cannabis patients themselves. And I don't know if you've ever looked at what a wage scale is for most entry-level jobs in the medical cannabis, but it doesn't pay a whole lot. People are here because they love what they do, and they love to be able to help people, and they know how impactful and positive cannabis can be. So not allowing them to be able to do that, to medicate themselves, it could create a situation.
And I guess what I'm asking is it, wouldn't this then require a change in the law, not the regulation? That's what I'm trying to find.
Well, it could, but because the change in regulations that are within your purview, which this is, and it would be for the betterment of the industry, which is within your power, that would be how you would make that change, instead of it having to be legislative, because you, as the regulator, you can say, hey, this would have a negative impact on the industry as it is written, and you can change it. If maybe I misunderstood that, but I thought that was something that was within your power and your purview to make that type of change if the legislation puts an undue or unfair burden on the industry that you're regulating.
That's fine. All right, we'll look at that. And the final question regarding is regarding social equity. So the social equity program, of course, is established by statute. So what change would you require to allow your business to participate? I know that we had a public hearing before, so is it what we had in the public hearing, or is it something different?
Great question, Chairperson. So what would allow us to participate would be, I think what's necessary is an inclusion in the parameters of that bill. I think what it currently does, or in the current statute, we are excluded and sequestered into what is effectively a gray area in the regulation. And so I think to that point, it may require a legislative change, and that's something that we are open to working with the board, and would really appreciate and welcome the board's help in making that happen. As I'm sure you recognize the challenges that are being faced as we had our discussion in the hearing prior to today regarding some of those challenges. So I think that getting the board's support on those legislative changes and to make those happen, to make sure that not only ourselves, but every other social equity applicant that follows does not end up in that same legislative gray area, is incredibly important. And it's something that we are continuing to pursue. And the last thing I want to say, because I know that you said this is your last question, is that I sincerely appreciate all of the board's questions on our written comments. We did spend quite a bit of time combing through the regulations and providing those because it's very meaningful for us, and we see the value in spending time having these conversations and providing that feedback. And that's exactly the nature, and the past 10 minutes is exactly the nature of the Social Equity Advisory Board that we are proposing. Because as you can see, there's been a ton of clarification and industry subject matter expertise that's been lended to this discussion, and that's going to allow us to have informed policy moving forward. So I think everyone on the call and the board would agree that this has been fruitful and productive, and we would absolutely love to see it continue. And I think it'd be a travesty not to put something permanent in place to ensure that these discussions continue, because as we know, the regulations are going to continue to change as the market develops. So let's make sure that we have the right discussions prior to those regulations becoming enacted and enforced, to make sure that all of the consequences, both anticipated and unanticipated, can be accounted for and dealt with prior to those, that fallout occurring. So once again, I appreciate the board's time. I appreciate the discussion and the questions. It's been incredibly meaningful, and thank you for your time.
And all right, thank you. I just want to inform the public. I'm asking questions. I know I give the other board members an opportunity to ask questions, but I'm asking questions based on written comments that the agency received. So since we received written comments, the board members can review those written comments and have fruitful questions to ask. I don't want to sit here and just off the bat just ask questions. So if I saw a comment saying that why is it questions are being asked? Well, questions are being asked because we got written comments that were provided previously, and so therefore I've had an opportunity to review them, and so therefore I can ask questions based on the comments. I do not want to ask questions off the fly based on just someone just testifying and just ask a question off the fly. And that's one of the reasons I have not asked questions. But the only question I'm going to ask, Ms. Khan, Mrs. Khan, you had mentioned the fact about the problems that you're having, or your clients were having with the application. Now, I've been telling folks that, you can go online, apply right now, and you'll get a card. So what is the problem that your customers are facing?
Our patients are going online, and most of the time, the majority of them are able immediately to get a payment link and to pay and get their registration. But as I said, over the past quarter, 50 of them have received nothing. And some of that is because of patient error. They either didn't complete it or they completed it with information with the wrong email address, whatever, but they get no response. So they don't know what to do. On your website, it does say, please don't submit a second application. Many of them have done that because they don't know what else to do. And then they don't get a response. So what I do is I contact the ABCA offices, and your staff has been, for the most part, very, very timely, because often they're waiting outside, yeah, and help guide them through. But because they get confused. Not everybody is, many of our patients actually are not computer literate, and they don't understand what to do. So they contact us. But 30% of the problems that we had over this past quarter came after hours. And obviously you can't staff your offices and 24/7, I mean, or whatever our hours for our hours. But if we could have a workaround, if we could have some kind of number that we could enter into metric system, so that they would be able to purchase, because you're just asking for their information. We have that. And then they could have that patient identifier. And then once working hours have resumed, then you would be able to get more information from them. But because now they're either waiting, we've had people wait an hour and then in anger leave while I've been trying to contact people, or they just leave and say, forget it. And then right now they go a couple blocks away to the next illicit dispensary, and nobody asked them anything. And starting July 1st, they're going to be able to go 2 blocks away from where we are and go without a problem. So it causes, and then we get nasty reviews, and it's not our fault.
And I just want to interject. Some of the problems.
I'm sorry, Mr. Khan. You need to identify yourself for the record. So remember, we have a court reporter. So identify yourself when you speak.
Joshua Khan, Tacoma Wellness Center, and I just want to interject on what my mom was saying regarding why it's happening. It often happens with certain email addresses. You know, when someone comes and registers using a Hotmail email account, they might not get that response so quickly as opposed to a Gmail account. Sometimes the system has crashed. The registry on with ABCA, simply they just get a blank screen. So there's been a few days where for about an hour, a few different times, someone will register and just receive a blank screen. But the biggest issue is when a patient applies for their second visitor card after the first one has expired. If they accidentally use the original payment link to pay for their second visitor's pass, it will get stuck in limbo because they need to use a new payment link. But it's not really written on the website anything about this, and we often have people come to us after submitting their payment on the original payment link, and they've heard nothing. So they come to us asking for help, and we hope that they come to us before 4 p.m. Not on a weekend.
All right, thank you. Any questions by any board members before I move on to another panel? All right, thank you very much for your comments today. Again, written comments can be submitted on or before July 20, on or before July 21st at, June 21st, on or before June 21st to abca.legal.dc.gov or once we've published the new regulation, then you'll have 30 days to do that. So thank you very much for your appearance and testimony today. All right, thank you very much. So let me call the next panel. All right, so the next panel that I'm going to call is the Generation Equity Movement. So Donald Temple, Mackenzie Mans, Kim Johnson, William Harris, and Lorenzo Bellamy. They're from Generational Equity Movement. They're the folks I'm going to ask to be elevated. And we're going to be off the record. I'll be off the record for 2 minutes, please. Okay, I'll be off the record for 2 minutes, but please elevate those parties. All right, we're back in the record.
Those who are in attendance have been elevated, Chairman.
All right, thank you. Let me make sure that we have a quorum. We need at least a quorum for the agency is 3 board members. So I need to make sure at least 3 board members are online. So I do see 3 board members online, so we do have a quorum. All right, now all right, let me see. Let me see who. So let me just ask a question, Mr. Either Mr. McKenzie or Ms. Mans. Is everyone from your group, are they online? Or are we missing anyone?
Everyone is online. There has been a change, Mr. Chairman, and Kim Johnson, William Harris, and Donald Temple are no longer testifying today.
Okay, fine. I know that there was a change, but then I thought, all right, that's fine. All right, so who wants to go first?
I'll go first, and then I have my colleague, Mr. Bellamy, go after
Fine.
me.
So can you please identify yourself for the record, and then you can, I'll start the timer.
Absolutely. My name is Mackenzie Mans, and I'm testifying on behalf of Generational Equity Movement.
Go ahead, ma'am.
Good afternoon, Chair and board members. Generational Equity Movement is an advocacy coalition that's been successfully advocating on behalf of Black-owned gifting shops since 2019. We organized the community twice to beat back emergency legislation that threatened to shut us down, and we've worked closely with Council over last year to create the law that is now in place. We largely applaud the regulations that we're talking about today. We know that they represent a pared-down version of what was recently in place, and they create a low barriers to access for a lot of the applicants. Although we definitely are frustrated with the social equity set aside, we understand that that issue needs to be taken up with Council and not with you. And my colleague will speak more to this. So we really just wanted to say thank you for all the work that you put in to these regulations, and we're excited for our continued communication as we watch this process play out.
Thank you. Fine. So, all right, let me start. Hold on. So you're going to now testify, Mr. Bellamy? Please identify yourself for the record.
Yes, Mr. Chairman. Thank you. My name is Lorenzo Bellamy, Lorenzo Bellamy, Bellamy. And I am a consultant for Generational Equity Movement. Here to just talk very briefly about these proposed emergency regulations. I want to commend you, Mr. Chairman, for in the beginning talking about the 8-ounce issue and that you all will be revisiting that. We hope that you will also consider revisiting the social equity definition. And there's been a lot of commentary on that. And so I've testified on many hearings, different bodies. And when you have someone and a group of folks who have testified on the same issue and pretty much are going to reiterate, or I would be reiterating what they have already said, the thing I would say at this point would be me too. So everything I would say that the Mr. Pritchett and Senior and the second, as well as Mr. McGowan and Ms. Kinner, when they were talking about the social equity piece, we are 100%, well, 99% with them on that and agree and hope there will be changes made. We also recognize that this is probably an issue for Council, and we are reaching out and have reached out to Council as recently as this morning to express our concerns about the social equity piece and hope that that can be expanded as well. We also think that you, Mr. Chairman, and your colleagues on the board can play a role on the social equity definition and expansion of it as well. And so we are asking that you would assist us and the staff at ABCA to reach out to the Council. I think they're prepared to hear from you about how they can make changes through emergency legislation to the definition of social equity. We want that to be expanded and not limited as we see it in its current form. There's also the possibility as well, Mr. Chairman, of even reaching out to the mayor herself and the administration and maybe seek an emergency executive order, and make the change that way. So I want to briefly just mention, since some folks have been talking about Maryland, Maryland has, in my opinion, a more expansive definition of social equity. We think that that is more inclusive. It doesn't limit it to, simply being incarcerated. And I know Mr. McGowan mentioned maybe just looking at one of the criteria as opposed to two, and that would be a potential solution. But we also think by expanding it to include some of the language that is in law, which will become effective July 1, we think that that is a good example of how to encompass and embrace social equity. We also think that there was mention about a social equity advisory board. We think that's a good idea, as long as we can make sure that for my clients who are unlicensed right now, that any delay in approving social equity applicants does not run afoul of the timeline that we would have to apply. I think Commissioner Grandis mentioned, we are aware that this is a privilege, not a right, but we think that, we are in good faith trying to be good actors here and hope that this commission and potentially the council would be good actors as well to extend courtesy and grace to us to extend or at least not allow us to bump up against the safe harbor provision that will be that will terminate. So we will be submitting comments, Mr. Chairman, following up on our testimony. We're also reaching out to the council to see the appetite they would have. Some specific members of the council who have indicated during the hearing last year and early this year that they would potentially seek emergency legislation if things look like they weren't working. And from what I'm hearing today and from what you all are hearing today, things are not working and potentially need some fixes. And I think you've identified some of those. Many of the panelists have already talked about that. I think there's going to be more panelists who will be bringing up some of the similar issues as well. So I'm going to save you 57 seconds here. Man, 5 minutes goes by fast. I thought I'd only be on for like a minute or two. But anyway, appreciate hearing us and look forward to working with you and also keeping you informed about our conversations and efforts with the council. Thank you very much.
All right. Thank you, Mr. Bellamy. As you are aware, the social equity is a statute that has to be addressed by the council. And I have been going to several conferences and trying to find out myself, is there a state that has a workable social equity program? Are there any states out there that have a program that you could recommend? Because I have gone to several conferences.
Yeah.
And I was recently in New York. I participated in a symposium, the Cannabis Regulators of Color Symposium. I went to that in New York and there were a lot of different states were there. And I'm trying to find out, what state out there has a social equity program that works, that actually works, or that you'd recommend that this is something that should be followed? And even if the board is going to get involved, to recommend to the council to say, look at this is what the state has done. Look at this state.
Right. Mackenzie, I think, has the answer to that, Mr. Chairman. Go ahead, Mackenzie, if you don't mind.
Yes, Mackenzie talking. Sorry for the record. New Jersey is a great resource that we should be looking at. What they have is like a 3-tiered system. And so they have an ongoing rolling basis for social equity prioritization. However, if there's no social equity applicants in the queue, then they move to economically disadvantaged individuals. And then they move down another tier to impact zone individuals. And so it really rounds out people who have been affected by the war on drugs in multiple different ways and ensures that there's preference given for all of those individuals. I think that would be a state that you should look to for advice or answers on what we could emulate, as well as Mr. Bellamy said, Maryland. I think Maryland's got a great definition, and their law is really amazing because they baked in a lot of time for the board to go back and make sure that the first round of licensings accomplish the intent and the spirit of the law. That's something that DC doesn't have in their law, but I think is something that we should look to as a practice that we could emulate.
All right. Thank you very much.
Mr. Chairman, if you don't mind, if I may just add and plug the Maryland language, and we can forward that. If you haven't seen it, we can certainly send that to you in our follow-up written testimony, which outlines some of the things that Mackenzie has been talking about. They have a disparity study process as well. I think there was a mention about the social equity advisory that may be similar as well in terms of, let's look at this and is it really working and what are the true needs and depth of social equity as it relates to the disparities that have happened in the medical cannabis and also in Maryland now with recreational.
Well, thank you for that. I would ask that you can submit that to ABCA.legal. And again, it's a statutory change from the council. And so whatever, if that's something that you require, then of course, I think you describe yourself as lobbyists. So therefore you need to lobby the council to have the statute change. And we, as you know, the board will write and implement regulations based on the statute that that enabling statute.
We appreciate that. Thank you.
Any questions by any board members of this panel? Yes, Mr. Grandis.
Thank you. Miss, is it Miss? I'm not having your name. What's your name, ma'am?
Miss Mans, Mackenzie Mans.
Mackenzie. Okay, I see it here. Thank you. I want to thank you for your excellent presentation today, and we've heard discussion about having a formal advisory board. I think what we're doing this morning is an advisory board, and you all have really, you and the other panelists have really enlightened me, and I'm sure other board members, with your very thoughtful and good life experiences to help us frame a good program. I have some challenge of the idea of going down a ladder for social equity to the point of, let's say, being in a disadvantaged area because of life circumstances. I have been blessed. Okay, I've had opportunities, but I also could be living in a disadvantaged area, and I don't think that. Well, I have a hard time seeing the fact of where I may be living would let me overstep someone who truly is who we are looking for through our council and through our agency of really helping people who, have been wrongly arrested, who have had challenges of not having the economic opportunities that other of us have had. So do you all have any thoughts that you all could provide after this hearing on why we should look at perhaps the fact of living in a disadvantaged area? Because I worked many years on trying to be successful with the residents of Anacostia to have the Anacostia bid. And the whole idea was to try to bring economic opportunity to the small business people who had been there for generations, but needed help to through regulation to promote their neighborhood so that people wouldn't have to get in a bus or metro to find a grocery store or other type of things. So I really support the whole methodology of trying to find different levels on how we get to the right people. But maybe after this hearing, you can help me because with the idea of living somewhere, because I don't know if that really is a way to parse this economic opportunity, this social equity. Thank you.
I'll just follow up briefly that I completely agree. I think that there's an opportunity for people to use that qualification in a way that the spirit of the law and what we're trying to achieve is not, what we want. What I would say is that it wouldn't just be that qualification. We would pair together multiple qualifications so that you're not just having lived in a disadvantaged area, but you also potentially attended a public school in a disadvantaged area, or, like we have right now, you made less than 150% of the median family income. So we would definitely work on pairing together qualifications so that it cannot be abused by people who the law was not intended for.
Perfect answer.
Thank you. Mr. Chairman, thank you.
All right, thank you, Mr. Grandis. I would like to thank you for your presentation today. And again, you can send written comments. Your written testimony can be provided to the agency on or before June 21st. All right.
And Mr. Chairman, thank you for that. And we do recognize that it is a legislative fix, but we also are encouraging you as well to use your authority and influence as well, and flexibility as well to review some of this on our, in support of what we're trying to say. We do understand we are going to go the council route, but I think there's also a role that you and the staff and the advocate can play as well.
All right. Thank you very much for your
Thank
testimony
you.
today. Have a great day. Thank
You too, sir. Thank you.
All right, the next panel that we're gonna call is Matt Lawson Baker, David A. Moore, Robin Walker Salas, and Norbert Pickett.
Hello.
Hold on 1 minute, please. Hold on 1 minute. Just want to make sure everyone is, all the names I called, that they're elevated, and then we'll start.
I believe I got them all, Chairman.
All right, thank you, sir. All right, so let's start off with Matt Lawson Baker from Alternative Solutions. Please identify yourself for the record, and then I'll turn the timer on.
Yeah, good afternoon, board. It's Matt Lawson Baker here. I'm the president of Alternative Solutions Cultivation Facility and DC's finest. We've been operating since 2015, January of 2015, in the existing medical cannabis market. And I appreciate all your work that you've done for these new regulations and looking forward to them being implemented. Today, the major point that I want to bring up, and it's to reinforce what's also already been raised previously by some of the operators, is based on the limits that have been restricted on concentrates. Again, I want to give you some perspective from the supply line impacts that will have. Right now, we're talking about reducing the concentrate monthly limit to less than 5% of what it is currently. This is going to have a big impact on the market as a whole, but also the expansion that's proposed with this legislation. Right now, the current operators are obviously going to be able to easily provide enough products for the marketplace, and they will also be expanding product lines to be able to make sure that we can get as much product biomass extracted and turned into concentrate products. So this will impact the new manufacturing license holders coming into the market, as the current operators will be utilizing most of that product. So when we're talking about trying to expand the market and provide more opportunities in the DC market, this is actually doing the opposite. All of the points that were raised previously based on how this affects the patients, I want to reinforce those as well. A lot of patients relying on these products, and they've been using them for many years now. And once you reduce this limit, it's going to have a big impact on them gaining access to their medicine and their treatments. So that's a major point that I wanted to bring up for today. Thank you.
All right, thank you, Mr. Baker. All right. Okay, so let's have Mr. Pickett.
Hello, good afternoon, everybody.
Good afternoon, sir.
Thank you, ABCA Chairman Anderson, Executive Director Musali, and the ABCA board for allowing me to add my voice to this discussion. Also, congratulations to ABCA City Council, Mayor Bowser, Chairman Anderson, Executive Director Musali, and all the licensed operators who worked so hard and tirelessly on drafting and passing the Safe Cannabis Act. I believe it helps advance the industry, and it's a good bill. So thank you for all those that participated on that. It wasn't easy. My name is Norbert Pickett, and I'm the owner of Cannabliss, the 7th medical cannabis dispensary to come online, located in Deanwood, in Ward 7, in a predominantly disadvantaged and developing neighborhood east of the river. Currently, we are the only solely Black-owned medical cannabis dispensary that's unionized in the United States, unionizing with the UFCW Local 400. There are two issues I would like to spotlight this afternoon. One being the ending of the sliding scale discount regulation, and the second issue, the 30-day concentrate limits I know that we've all been addressing earlier on in this hearing. I am uniquely qualified to speak on both issues, The original cannabis legislation provides for a sliding scale discount or so-called red box sales of 20% discount to economically challenged patients. The regulation is outdated because the price of cannabis has declined significantly since the regulation was created and is no longer needed because the price of cannabis has gone down more than the discount. Let me repeat that one more time. The price of cannabis has gone down more than the discount. In the beginning of the program, there was a plant count and lack of supply. Therefore, prices were high, around $25 to $28 per gram. With the plant count cap removed and with more supply, the price per gram has been reduced to $7 to $9 per gram. And discounts are offered on other products as well that the red box patient can take advantage of. So the regulation is no longer needed or relevant to the affordability for the patient. We fought to bring down prices, and they have been reduced over 300%. The discount accounts for over $1,351,239.80 in lost revenue for cannabis since we opened in 2019. $1,351,239.80 of lost revenue for a new business. Soon it will be 1.5 million, then 2 million, then 2.5 million. When will the bleeding stop? How much more can this small, solely Black-owned business sustain for it not to be in the red? I finance this business by myself with my own money. If this regulation is eliminated, the business can pay off its debts. If the regulation continues to exist, the business will be in debt. 50% profit automatically gets reduced to 30% profit, then gets further reduced to 0% profit after we pay for labor, income tax, unemployment tax, payroll tax, Tax 280E, paid leave, workman's comp insurance, product liability insurance, legal, accounting, payroll, rent, electric bill, water bill, advertising, Dutchie, which is a POS system, POS banking fees, metric monthly fee, yearly licensing fees, packaging and labels, various government agency fees, employee badges, background checks, and other expenses that are paid, none of which the illegals pay. Let me repeat that one more time. None of these illegals pay any of these costs. The social equity problem and policy solution falls on dispensaries alone. As a matter of equal responsibility in spreading the financial burden of shared cost and shared benefit of this social program, cultivators should share equally in the financial impact. Secondly, the disproportionate responsibility falls on those dispensaries located in poorer neighborhoods east of the river. In addition, no effort is made to maintain records of changing income by patients. Patients who are qualified are not reevaluated or requalified on any periodic basis. Therefore, many patients who have become employed are still taking advantage of a program they should not qualify for. We would suggest that DC follow the lead of other jurisdictions that provide certain products at a steep discount for patients who cannot be able to afford top shelf products. That could come in the form of what is known as flower, shake, keef, and lower THC level tinctures, etc. Those products should be provided at a discount to dispensaries and further discounted by the dispensaries and set aside for low-income patients. A sliding scale of discount for designated generic rather than top shelf products that parallel various levels of need could also be instituted. The current system is racially discriminatory against Black owners operating in Black neighborhoods and doesn't spread the financial burden among those in the line of production and provision of cannabis.
All right, Mr. Pickett, you exceeded your 5 minutes. Please submit your written testimony to the agency so we can further explore your position, sir. Okay.
Thank you, Chairman Anderson. I submitted it this morning at 10:30.
All right, thank you. I haven't seen it because I've been on this hearing, but I look forward to further reviewing it. Okay, so let's have sorry, it's the Robin Walker Salas, and I think yes.
Good afternoon. I'm
Good
Robin
afternoon,
Walker Salas. I represent a fringe demographic with wounded warriors behind bars. As a patient and an advocate, I got to say I've never heard the word mentioned today about education. And I believe that the people are uneducated. Now, when you're talking about limiting the amount, like for myself, I have user error. So when I get RSO or concentrates and I'm not sure how to use it, I'm wasting a lot of product. Or if I get a strain of cannabis that I'm unfamiliar with and it doesn't react well with me, then I have excess and I have to find a way to get rid of it. So there's a lot of hit and miss that goes into the amounts that are allowed, and also the education part of it. Now, I personally feel that a peer review type of situation, like a mayor's office of cannabis culture, where if people are willing to register to say, hey, I can help you learn about cannabis and help you through the process. And we make it so that we're supporting each other. We're Americans. Nobody should be discriminated against. As a veteran and all these other things, I think that there needs to be for things that are equitable all the way across the board, and education should be one of the things they put in as far as being able to obtain anything when it comes to cannabis or cannabis products, because miseducation creates a lot of issues.
Oh, that's it. The end of your testimony, ma'am?
I believe so. I really feel that we should have more community supported type of cannabis culture and cannabis industry geared towards that, because if we're going to keep each other in check, it's a lot easier than if we have to have a government person that has to do all that all the time. Does that make sense?
Thank you for your testimony, ma'am. All right.
Great, thank you.
Any questions? Any questions by the board members of any other witnesses?
Yes, sir, Mr.
Go
Chairman.
ahead, Mr. Grandis.
Is it Miss Walker? Miss Salas?
Yeah, Miss Salas. Salas, Robin, R-O-B-I-N, like the bird.
Yes.
Salas, S-A-L-A-S, same backwards as forwards.
Thank you. I find your information very interesting. So help enlighten me. If you go to a DC dispensary, is there someone there, or would that be a place that people who need information and guidance on dosage or the difference of the different strands, would that be a place to get that information? If it's not now, is that some, help me with, where would you think? Yeah, go ahead.
It's my understanding they call them bud tenders, but as medical cannabis, they're not really allowed to expound on any kind of information. And when it comes to the different strains and the effects, not everyone is educated on all of everything. That's just too much to learn from one person. And I don't think it's the bud tender's job to recommend one way or the other. Now, maybe they can enlighten, say, it's a sativa versus an indica, but if a patient doesn't know the difference between the two or how to use the different kinds of concentrates. Go ahead.
No, I'm listening. This is very enlightening to me, because I wasn't tuned into the concern you're raising, which is a very, very important concern. So it's just, where would we, if we followed the line of trying to come up with policy regarding to meet the concern you have, where would we place this type of person? It's just, we want to help. I think what your concern is very important for us to be aware of and figure out if our board is a place with the agency to come up with a solution.
Again, theoretically, the doctors are supposed to be the ones prescribing, but unfortunately, the doctors don't know as much as, say, the growers or the dispensary owners or someone who's been in the industry for a while. I don't see any kind of screening for educational of whether a person knows what they're actually obtaining and how to use it. That's been my problem. I've obtained things and not know how to use it, or it's not the right product or whatever like that. And then I exceed the amount I'm supposed to have in possession because I'm not using that, and it's just there till I see my friend or something, you know?
Thank you, and we will discuss this issue. I want to thank you for bringing it to our attention.
I really would like the idea of a mayor's office of cannabis culture. We have all kinds of mayor's office of all kinds of things, but cannabis culture exceeds past sex, race, or any of that stuff. Cannabis culture is just cannabis culture.
Well, thank you. Is Mr. Norbert still available? Mr. Norbert? I guess not. Mr. Chairman, I'm fine. Mr. Norbert may not be available. Thank you. Thank you, Mr. Chairman.
All right. Thank you, Mr. Grandis. All right. If there are no other questions, then we're gonna dispense with this panel, and we're gonna move on to another panel. The next panel we're gonna move on to, it's Jen Bunkenhart, Michael Bobo, Chad Frey, and Yvette Alexander.
One second, Chairman. Apologies, Chairman. Did you include Linda Green?
She's not tested. She's not available. I'd gotten a notation that she was not available to testify. That's why I didn't call her name.
Okay, thank you.
I'm sorry. And Michael Bobo, he's not testifying too. So, right. So it's I'm sorry. So it's Jan Bunkenhart, Chad Frey, and Yvette Alexander. So any of those, I thought I saw a chat note from Miss.
Yeah, I'm not even seeing. Oh, I see her now. I believe that's the only one present.
All right. Well, if Alex, why don't you then elevate Subra Hall, Brittany Carver, Angie Pope, and Oliver Pearsons. See if those folks are still online. So it's Jan Bunkenhart, Bunkenhart, Chad Frey. I see Miss Alexander. I see either Mr. or Mrs. Paul, Miss Carver, Miss Perker, Pirko, and Miss Persons.
It appears that only Yvette Alexander is the one present.
All right, what about Gretchen Kolsky, K-O-L-S-K-Y, Leela Lewis, and Cleo Kruger?
I have elevated only the ones present.
All right. Okay, so all right. And Miss Alexander, you only have 5 minutes. So not because I've called all these folks and they're not aware, they're not around, that you're gonna think that you can use their time. Okay, Miss Alexander, I'm now in a position to cut your time off. Remember, you used to be in that position where you tell them that they have 3 minutes to speak, and I thought, now I have, all right. I having some levity with this. All right, Miss all right, so Miss Alexander, can you please spell and state your name for the record, please? And you have 5 minutes. I'll start the timer once you identify yourself.
Thank you. If you indulge me, Norbert Pickett, I think someone had a question for him. He said he was available to answer that question.
I don't think, I think Mr. Grandis had moved on. So So that's it. All right, fine. I
Okay.
saw that he had put something. So please identify yourself for the record, please.
Thank you. Yvette, YVETTE, Alexander, ALEXANDER. I'm a consultant for the DC Cannabis Trade Association.
Go ahead, ma'am. All right.
Thank you. Greetings, Chairman Anderson and members of the board. I see also my neighbor and friend James Short there too. Hello, all the board members. So glad that you allow me this testimony. As stated, I'm Yvette Alexander and I'm representing the District of Columbia Cannabis Trade Association. The association was formed to improve access for patients in our city's medical cannabis program. The members represent the licensed medical cannabis cultivation centers and dispensaries in Washington, D.C. The association would like to thank you all for your work and commitment to the medical cannabis program, and we look forward to your continued support. We have several recommendations for your consideration regarding the proposed rulemaking to implement the Medical Cannabis Amendment Act of 2022. We are pleased with the law that allows for the out-of-state self-certification, but a reduction in the fees charged are necessary for the licensed medical dispensaries to remain competitive and give patients an incentive to purchase safe, legal, and tested products. Currently, the fee is $30, as you know, and that has really caused a burden to our dispensaries. There is a recommended structure program that we have discussed with the agency. We think the $30 for just the 30 days is too much, and it has caused a problem for those patients to go to maybe illegal place to purchase that doesn't require that. So we have a fee schedule, and I will present written testimony. Say, for example, $5 to $10 for 30-day, and then as you extend, maybe $15 for a 45-day, and $30 would allow 2 to 3 months or more for a patient to purchase cannabis. And we also have to keep in mind that I think someone stated July 1st, Maryland will open up its recreational program. And currently Maryland is issuing medical cards, I believe, for up to 6 years for $25. So we know those are neighbors right across the border, and patients can easily go there. So we want to maintain our competitiveness in the District of Columbia. Also, the sliding scale, which mandates a 20% discount to low-income patients, and I believe that was mentioned as discriminatory in a previous testimony. But the sliding scale is taken from the revenue of the dispensaries with no tax credits or reimbursements from the city. And this impacts the financial means which to succeed. And it has an unintended economic impact on those who are currently undercapitalized and work in undercapitalized communities. For example, Ward 7 and Ward 8, they are being unfairly targeted for this sliding scale. And with that, we also recommend to eliminate the sliding scale report. Metric system currently tracks from seed to sale, so that report is not needed. With the passing of the recent legislation, there will be opportunities, we know, for more businesses to obtain their medical license. However, we do think it is very important before these licenses are issued that there would be a supply and demand study conducted by ABCA, because we need to know the amount of dispensaries and the amount of cultivators that are needed per capita of the persons who will participate in the program. Right now, there is a burden with supply and demand with the existing cultivators and dispensaries. So to add more to that, we really need a study to capture the amount that is really needed for our market, for our cannabis, our medical cannabis program to continue to thrive in the District of Columbia. We don't want to limit, we don't want to discourage I-71s, but we know that it can't be a come one, come all with the amount of the operators that are currently in the District of Columbia. So we really need to do a study, and we need to have some solid way that you can, that the board is going to present, or that the agency is going to issue new license for that. It was mentioned earlier about the concentrates, that we really need to increase the amount of concentrates for some of our patients that require higher dosages of cannabis, that don't opt to vape or smoke flower product. So we would really need to increase that, and the recommendation would be up to 8 grams per day for concentrates for our medical patients. And I believe Tacoma Wellness said that in detail. So I won't prolong that again for that, but I will present that written testimony. And the other concern would be the internet retailers. I know that that was a part of the Medical Marijuana Amendment Act, and we really need to know how we're going to regulate those internet retailers. It's recommended that the internet retailers would only be issued, that license would only be issued to those businesses that already have a brick and mortar business, because that can be regulated. Other than that, the internet retailers are no more than a delivery service. So
all right, Miss Alexander, I gave you 6 minutes, so I have
is
to.
that, oh my God, that
Yes,
went
I
by
did give you an
fast.
additional minute, but so please submit your written testimony.
Will
and
do,
I
and
will-
I'm open to any questions that you may ask, but it really is important that we're not saying delay the license for new businesses, but we are saying that there needs to be a study to see how many new businesses are going to come on board in the DC market.
All right, thank you, ma'am. Now, Miss Leila Lewis, I see that you're here, Miss Lewis. Miss Lewis, can you unmute yourself, ma'am? Miss Lewis? Mr. Orion, I see Miss Lewis online. I'm not sure what is going on with.
I sent her a request to unmute. I'll reach out to her.
Okay, thank you. While we're waiting for Mr. Lewis to unmute, to be unmuted, Miss Alexander, is there anything else you want to say until Mr. Lewis? I'm trying to, since Miss Lewis is online, and I'm trying to have her speak. So while we're waiting, you can speak until she, if you so desire.
Thank you. I cannot stress enough for the 30-day fee for the self-certification. That has really hindered a lot of our businesses, because people can opt to go to I-71 or to these illegals and they don't have any fee charge. So, we want to, like was said previously, that these are the businesses that have invested in the city, that pay taxes in the city, that abide by all the laws and regulations in the city, and they have weathered the storm. So we would like to see that same, deference given to them, that we have invested in the city, that, you make it as as easy for them to do their business as possible without all of these restrictions and things that get in the way of them to be successful. They really, believe it or not, have not made quite the profits that people believe they have made for all of the regulation and all of the fees that they paid. I would even recommend for the I-71s that I do truly believe that some of them want to become a legal medical cannabis business, that they could start doing some of the things that the legal businesses are doing. They could start paying the taxes on their cannabis sales. They could start paying fees. They could start taking, going through the metric system and the regulations that they need to once they enter the legal business. I mean, they really need to, I think ABCA really needs to take into consideration those that are serious about this and really let them know what it is actually like to conduct a legally licensed medical cannabis business in the District of Columbia.
Thank you, Ms. Alexander. Ms. Lewis is having some issues, so she stated that she will email her testimony. So thank you for your testimony, Ms. Alexander, and Ms. Lewis. I look forward to your testimony. It's abca.legal@dc.gov, and please email that to us prior to the June 21st. It appears that you have a question you want to ask, Mr. And I'm trying to move on because I'm trying not to take a break. I know that I have about 11 more people to testify, and I want to see if I can move through all of those witnesses before taking a break for the board, since we've been here since 9:30. So go ahead, Mr. Short. You're on mute, Mr. Short.
Good afternoon, Council Member Yvette Alexander. I'd just like to say, ask you if you would elaborate just a little more on the out-of-state fees, and how do you think that reducing them or otherwise working to make it better for the public, what are your suggestions dealing with the out-of-state $30, 30 days?
Thank you for asking that. Once again, I think the recommendation would be a lower fee. We realize that, I mean, through fees, that would be the way that your agency, the agency makes money. I mean, you have staff and you have things that you need to support for that. So we know that there's a fiscal impact involved in anything that there's a cost attached to. But for when you compare to residents or out of state being able to walk in other places without any fee whatsoever for purchase, when you look at that competition, it would really be fair to say no more than $5 to $10 for a fee for someone to just come in and get that, and self-certify, or for the out-of-state self-certification. That would make sense. That if I was coming in, you're already going to have to purchase the cannabis. So for that time, that may be a one-time purchase for someone, that a $30 fee on that is way too high. So it would be fair, $5 to $10 for 30 days. And then as the time increases for your ability to purchase, then the cost would increase. Say $15 for a 30-day, and the $30 could be for 3 months to 6 months. So it would be a graduated fee depending on.
Now, I'd also like for you to, if you could, to elaborate on the increase in oil, again, increased dosage. We heard testimony about that today.
Now, I'm not an expert on that, the way that the dispensaries actually are, but pretty much the increase, you would need more for a concentrate than you would need for the flower product that a person may vape or smoke. That's a larger quantity, but for the concentrates, you would need, well, I'm saying that's a smaller quantity compared to the concentrates. I would say, for example, for 8 ounces of flour, you may need, 2 or 3 times that for a concentrate, if not more. So the 8 ounces of flour does not equate to 8 ounces of a concentrate. You would need more of a concentrate to get that same effect. So we're saying do not limit the amount of concentrate, because persons would need more. There's more of an amount that you need for a concentrate to be as effective as that same amount of a flour product. pretty much.
Well,
And some people don't opt to smoke. Some people opt to have oils or tinctures or suppositories, whatever, other means to medicate themselves. So you would need a higher dosage of that particular product.
I do thank you very much for your testimony. It's been quite compelling. That's all I have, Mr. Chair. Thank you very much.
All right, thank you. All right, I'm going to move on to another panel. All right, since I was told that I believe that the numbers have, so I was told these are the people. So Mr. Oriana, can you please elevate, and since you've told me these are the folks online, Barbara Biddle, Terrence White, Stephen Slaughter, Daryl Dawson, and Chris. There's a Chris C. I'm not sure if that person, I'm looking at my list and I don't see the last name, but can you elevate all those folks? And after Mr. Oriana has elevated the names I just called, if there is anyone else online who wants to testify, can you please identify yourself in the chat, and I will have you elevated after this panel is done. So I think this is the last panel of people who have informed us that they want to testify. So if there's anyone else online who would like to testify, please identify yourself in the chat, and then we will elevate you for the next and final panel. Okay. Mr. Oriana, is this everyone that was on your list?
Yes, apologies. This is everyone.
All right, fine. So let's start with Ms. Barbara Biddle. Can you please identify yourself for the record, please? And then after you've identified yourself, you'll have 5 minutes.
Yes. Hi. My name is Barbara Biddle. I'm the owner and founder of District Hemp Botanicals. I'm also the board member of the Virginia Hemp Coalition and a member of the I-71 committee. I want to start off by saying that I appreciate the opportunity to provide my thoughts and concerns as a small business owner and local community member, and how the incoming changes to the medical program will impact the district's industry. I personally came across CBD, the non-intoxicating compound found in the cannabis plant, while battling depression-like symptoms after the birth of my first son. And I've watched thousands of customers have life-changing benefits from these products since opening my first store in 2017. As an owner of a hemp retail business, it's critically important to maintain access for not only my customers, but myself. And I'd like to offer a unique perspective on the situations that have arisen in Virginia when it comes to the regulation of marijuana and hemp. Many businesses will not be able to comply with the regulations proposed by the new medical regulations. As businesses start to seek a safe haven once loopholes from the I-71 industry close, many will inevitably continue operations under the black market, while others may try to move into the legal hemp industry. In an effort to be preemptive and create an environment where small businesses can flourish under the legal conditions created by federal law while upholding safety standards, I ask you to consider a few things. 1, clarifying the legality of hemp-derived food products and regulating the production, processing, manufacturing, and sale of ingestible hemp products. Business owners and consumers alike want to ensure safe and reliable access to therapeutic hemp products, and there's been concerning comments made by local industries or agencies that challenge the ability of business owners that provide federally legal hemp-derived CBD products to their consumers. Part of facilitating reliable and safe access includes clearly defining that hemp-derived products, separate from marijuana products, are legal and implementing reasonable regulation on ingestible and smokable hemp products and creating a clear path for businesses and consumers alike to navigate the space. Requirements on packaging, labeling, testing, and age restrictions can help ensure that DC residents and visitors can acquire reliable products that contain the amounts of cannabis that's marketed on the label and give city officials peace of mind when it comes to the safety of these products. Explicitly allowing dispensaries to provide hemp products in waiting rooms without the regulatory and tax burdens found in the marijuana industry can also help alleviate some concerns. Not only could this help alleviate supply concerns as the lines between hemp and marijuana become less distinct with the proliferation of federally legal hemp-derived THC products, but it can also help with demand for dispensaries since concerns around patient tracking is a huge barrier for residents and tourists alike that prefer shopping with hemp providers or on the block market. Adding hemp retail, growing, manufacturing, and processing license into the new licensing structure can also help things. Examples to review include regulatory models implemented in Tennessee and South Carolina that utilize common sense guardrails without decimating small businesses in the industry. Things to consider would be allowing open licensing and capping licensing costs at $500 for CBD-specific businesses. This will allow the industry to still remain competitive and allow small businesses to operate in the space. 3, protecting the craft industry. Some of the most amazing products are made in small batches by local producers. It's important to allow this market to thrive and flourish and perhaps follow New York's lead by allowing sales at farmers markets and pop-up markets. These small producers are driven by passion and the need to help others, and this instills genuine creativity and boundless innovation unrivaled by most other industries. I fear some of the licensing requirements may be prohibitive to those in this space, and careful considerations need to be made as to whether licensing costs and location parameters can be changed to allow them to continue to compete. In regards to the process of rewarding licensing, I highly encourage you to postpone the issuance of licensing for medical retail locations until there are sufficient amounts of supply to handle the demand. I also recommend you consider tenure in your licensing approval criteria. Creating a first-come, first-served process will create dangerous situations for business owners in highly concentrated operating areas. Desperate times call for desperate measures, and many of these business owners will have nothing to lose and may utilize aggressive tactics to discourage competitors from applying. Currently, there is no urgent safety issues regarding hemp products in the district, but it's my intention to think ahead before a large proliferation of businesses enter the market and potentially change the integrity of the market. Without taking preemptive action, I watch things spiral fast in Virginia, and I'd like DC to learn from the mistakes of our neighboring state. Thank you so much for your time.
Thank you, Ms. Biddle. Mr. White, are you there? Terrence White? You're on mute, Mr. White. Unmute yourself, please. Mr. White, you have to unmute yourself. I cannot hear you, sir.
Sorry about that.
All right, go ahead, sir.
Good afternoon, Mr. Chairman and board members. Thank you for this opportunity to speak with you. I am Terrence White. I am the chairman of the I-71 committee, going on a year now. And today I come before you with a couple issues that I need for your consideration. Number one is cultivation and the lack of cultivation. Currently, the district has 8 cultivators, which 5 are online. Right now, up to year to date, we're talking roughly over 2,000 pounds of cannabis have been grown and processed and sold in the medical aspect. That equivalents to about 88,000 square feet of cannabis, which if you're asking another 25 to 30 I-71 or first come, first serve people to get into this particular market, there's going to lie a big issue with lack of cannabis. So today, what I like to do is present a couple of things that, as we're asking for your consideration, to take that up for consideration, is thinking about how we plan on moving forward and not being like states like New Jersey and Illinois as it pertains to cannabis. If we roll out the current legislation, we're going to be right back where we are with a huge illicit black market, because the problem will always lie. There's not enough cannabis being grown. And so therefore, I ask that you think about this very seriously. How do we tackle this matter? And that matter is basically comes down to this. We got 8.8 square miles, 800,000 people that we serve here in the district. but we also have to think about the 31 million people that visit the district on a year-to-year basis, or if not more now after post-COVID. So therefore, we have to look at how we plan on tackling this issue with also bringing along a new 25 to 30 licenses as proposed, and it could even be more. So therefore, I ask that you think about this very seriously, because if we don't halt the licenses that we're asking about and tackle the cultivation side, there will be a bigger problem. And that problem will go back to day one. The lack of cannabis being grown and the amount of licenses will never be created equally. And so therefore, my testimony today is based on fact. And as someone that's in the market, as you guys say, illicit, I-71, I can tell you 2,000 pounds of cannabis year to date, and here we are, you have 8 medical dispensaries that's doing 2,000 pounds, and you're asking for another 30 to 40 licenses to come aboard. It's going to create a massive problem at a massive intersection. And that's one of the things that I really wanted to speak about. The other part of my testimony is, as we ask these licensees to come aboard, we are not giving them the ample opportunity to serve their business properly. And what I mean by that is currently your 8 medical dispensaries, they're not able to advertise and market their business as any such other business. If we look at cities like Los Angeles, states like Colorado, let's just go state to state, New York, California, cannabis owners are able to express themselves and also able to market their businesses as such. Here, we're basically handcuffed. And so when you ask these businesses to come aboard, if they can't do print, if they can't market, if they can't do proper social media and other advertising and marketing strategies like SEO, SOLV, those type things in order to win, it's going to be it's not going to be fair, because some of these businesses already been in business 8 and 10 years, if not more. So now you're asking a new business to come and compete in a market with no advertisement or marketing. So that's something else that's critical, that's important to the I-71 committee, and also should be important to the district. If we want to maximize this $650 million potential in this market, we have to be able to allow everyone with the essential tools. And that's pretty much my testimony today.
Thank you, Mr. White. So, Mr. Slaughter, please. Please identify yourself for the record.
Hi, good afternoon, everyone. My name is Stephen Slaughter, spelled Steven Slaughter. Good afternoon, members of the board. My name is Stephen Slaughter. I'm the vice president for the I-71 committee. And I just wanted to express the gratitude for the opportunity to speak today. I hope every business owner here was heard today throughout this sentiment, obviously for the betterment of the industry. I'm here today to express basically my testimony today is to speak on behalf of basically somewhat of what Yvette said earlier, as well as what Terrence just said prior to Terrence White, who spoke to me prior, which is that basically in our industry at its current state, that there should be a survey, or there should be something done to understand what's going on in the market when we have these new licensees come on board from the Initiative 71 markets, as well as the sociable, equitable client applicants who come on board as well. I think there's going to be a huge problem when it comes to that, just in a sense that we have the cultivation centers that are currently representing the same 8 legal cannabis dispensaries right now. And we have a bunch of new people who are going to come on board in the next year. And essentially there's an imbalance that's going to take place. And I don't want to speak so much to that because I think it's already been spoken to, but I also think that there's going to be a huge problem when it comes to the capital for these new businesses that come on board. In some instances, we have, and you mentioned it earlier, where we have businesses that will have to shut down during a certain time frame while they wait to come on board to get their license. And in some cases, not having the ability to do marketing and not being able to function as a business during this time frame after the sunrise period has ended. I think it causes a lot of problems, and it sets new small businesses up that are coming into this industry up for failure in a sense, because essentially you're asking new businesses to start off and have a certain amount of capital without operating or being able to function their business for a set period of time while they wait to find out if there's a decision on if they can actually get their licensing or not. And I think that's going to cause a huge problem, especially for applicants who are coming on board, who take the sociable, equitable route to come on board. It's going to cause a problem there because we already have problems in our banking system with the Safe Banking Act, which doesn't allow for businesses to participate fully in the banking system itself. Myself, I have what you would call an auxiliary business in the cannabis space as we speak. And even for me, I find that financing and things like that can be challenging as I bring my business on board. And I think it causes a huge problem because if you're talking about things like merchant services, processes, which these new businesses will have to set up when they come on board, there's not a lot of big banks or not a lot of financial institutions that are able to help these new businesses out. And I think that's going to cause a problem as well. And I just think that that's something that should be looked at because there is going to be a period, even for I-71 companies who are able to transition into this new market where they will have to shut down and there will not be, the same amount of financing or funding coming in to allow them to be successful in this new market. And so that's pretty much my testimony for today.
Thank you very much, Mr. Slaughter. And so let's have Mr. Dawson, please. Mr. Dawson, please state your name for the record and then I'll turn the timer on.
My name is Daryl Dawson. Are you able to hear me?
Yes, I can hear you, sir.
Okay.
Spell your name. The reason why I ask everyone, we have a court reporter, so we have a transcript. So that's why I ask people to spell their name for the record.
Okay. D-A-R-E-L. D-A-W-S-O-N.
Thank you,
Oddly
Mr.
enough, I have a little echo. Hold on, let me figure this echo out. Hold on.
I don't hear one, sir. So
okay. Oh, that's a worse echo.
All right. I think you're on. Is someone else? Are you on two lines? Or is someone there?
Yes, I am. Hold on, just one second.
So that other person needs
to let's do
mute
this.
their phone. Mr. Dawson? Mr. Dawson? Mr. Dawson, I don't know what you did with your phone, but I'm not sure what
okay, wait, can you hear me now?
It's not a matter of what I can hear you, Mr. Dawson. I'm looking at something, I don't know what I'm looking at. So I'm not seeing your face. I don't know what I'm looking at. That's why, all right. Let me have Mr. Smooth testify, and then hopefully Mr. Dawson will be able to join. So Mr. Smooth, why don't you spell and state your name for the record? Please spell and state your name for the record, and then I'll turn the timer on.
My name is Christopher Smoot, C-H-R.
Hold on a minute, please. I think, are you and Mr. Dawson in the same location?
No.
All right. Mr. Dawson, all right. Go ahead. Why don't you speak, Mr. Smooth? Let me see.
My name is Christopher Smoot, C-H-R-I-S-T-O-P-H-E-R-S-M-O-O-T.
All right, you have 5 minutes there. Go ahead, please.
Okay. So I'm a member of the I-71 committee and business owner of an I-71 compliant business. First of all, I want to thank you all for the allotted time and the opportunity for myself and our committee to address the concerns that we see and that the ones, especially the ones that we feel strong about. I joined the I-71 committee recently because I believe in a sustainable and equitable entrance for the unlicensed owners in the cannabis industry in the district. In Washington, D.C. right now, even with only the 7 or 8 dispensaries that we have now, we see unprecedented diversity in the industry that we can't even begin to see across the entire rest of the nation. As a collective, us as the operators in this market, unlicensed and licensed, want to see and reach the success that we know is possible, and we are hopeful that with meetings like we have today, that we'll be able to make the necessary changes to walk forward confidently. So our biggest concern about the proposed regulations, and my reason for being here today, is to bring attention to the opportunity for success in a local cultivation hub in the city. So when we look at true demand versus projected demand, a lot of the I-71 businesses right now are shouldering the weight of the demand that the medical dispensaries could be seeing. This is due to a lot of factors, mainly patient access. As a lot of the people on here have said, the 30-day pass is a huge speed bump when people are trying to get their medicine, and they will turn to easier, quicker, and cheaper alternatives, as well as the inability to advertise and market and promote to those patients for all of the licensed individuals. In an industry that has close to no bankruptcy protection and close to no support from any type of financial institutions, it's extremely important for businesses that are in the cannabis sector to be able to market and be able to retain their consumer conversations, especially as the market becomes more competitive. DC has the ability to lead the nation in a new cultivation and a new manufacturing regulation. We can set a good example. As we've seen in many other states that previously have legalized, cultivation timelines tend to be a little longer than they are originally projected, and they can face a lot of hurdles on the way to actually being online. As everyone else has mentioned, the demand does not necessarily match the supply that we see right now. There's a supply shortage, I dare say, and if you were to add 20 to 30 new licenses, there would be no supply to meet those licenses. So you would be setting those businesses up to fail. Without the beginning product, which is the flower, which is the cultivation, there is no manufacturing, there is no extracting, there is no retail. So at the end of the day, the entire industry depends on the cultivation timeline being correct. And so that's definitely something that I think needs to be looked at in the current regulations. And in addition to all this, we in the industry know how tedious, how difficult it can be to set up processes and regulations for all of this stuff. And I, as well as pretty much all of my other colleagues from what I've heard, believe that a cannabis-specific advisory board would be extremely useful for regulators and legislators. I would like to recommend a group consisting of industry experts be assembled, cultivators, extractors, business experts, even maybe from other states that have previously and successfully implemented a program like this, to inform the board and everyone as to what the reality is of operating in this industry. And that's pretty much my testimony for today. Again, I want to thank everybody for their time. Yeah.
Thank you, sir. Mr. Smooth, thank you for your testimony. Mr. Dawson.
Yes.
Did we get our technical issues now straight?
I hope so. Can you hear me?
I can hear you, and I do not hear an interference. So can you please?
Okay.
Well,
okay,
so you have already introduced yourself for the record, and so you have 5 minutes, sir.
Okay. Hello, everyone. I'm Daryl Dawson, president of the I-71 committee, local business owner, cannabis justice advocate, and an active DC community member. I'm here today to voice my support for the temporary postponement of halting cannabis retail licenses in our district to ensure the successful establishment of cultivation facilities. With patient access to safe and sustainable cannabis products as our priority, we have a unique opportunity to foster social equity and create the change in the industry that we envision as a standard for our country. As of 2018, the first medical cannabis social equity program was enacted, and as of 2023, 0 of them have proven effective. Patient access to safe and sustainable cannabis products is of utmost importance. By prioritizing the establishment of local-based cultivation facilities before issuing retail licenses, we can guarantee a steady and reliable supply of high-quality cannabis products that allows retail licenses, that will allow access to patients in need. Temporarily delaying retail licenses allows us to focus on building a robust cultivation infrastructure that prioritizes patient and consumer well-being and ensures their access to therapeutic benefits of cannabis. We should also not be limiting the patient purchasing limits. That's important. If we are to create a thriving market with long-term local business success, regulators should not put hindrance on patient access. Moreover, our district has a chance to become a shining example of the social equity in the cannabis industry. As we move forward, it is vital that we address the historical disparities and injustices that marginalized communities have faced due to the war on drugs. By pausing the issuance of retail licenses, we can dedicate our efforts to create a framework that promotes and supports social equity and local businesses in the industry. This includes providing opportunities for minority-owned businesses, reinvesting in communities who have been disproportionately impacted by cannabis prohibition, and ensuring fair access to licenses and resources for all interested parties. We have the opportunity today to set a precedent for an evolving industry. By delaying the retail licensing processes, we can take the time to establish comprehensive regulatory framework that not only ensures patient access, but also incorporates social equity measures into the fabric of our industry. By doing so, we can create a model that other states and jurisdictions can follow, paving the way for a more equitable and inclusive cannabis industry across the nation. Furthermore, by prioritizing the successful establishment of cultivation facilities, we can appropriately address potential supply chain challenges that may arise from an influx of retail businesses. Ensuring an adequate supply of cannabis products for both patients and future consumers is crucial for the stability and sustainability of our industry. By taking a measured approach and focusing on cultivation first, we can avoid potential shortages, price compression, and compromised quality that may arise from an unbalanced market. In conclusion, I urge the board, council, and associates to consider postponing or halting cannabis retail licenses to ensure the successful establishment of cultivation facilities in our district. By prioritizing patient access, focusing on social equity, and setting a positive example for the nation, we can create a thriving and inclusive cannabis industry that benefits all stakeholders. Let us take this time to seize the opportunity to create the change that we wish to build and that we wish to see in order to build a cannabis market that is fair, equitable, and accessible to all. Thank you for your attention and your considerations. And it's wonderful to see all of you, like I just stated, it's wonderful to see all of you actually take this time, take this issue seriously, and give your ears to us. We appreciate it.
Thank you, Mr. Dawson. And this is my first opportunity in meeting the I-71. And so I'm glad that the I-71 committee, that they want to join the legal market. And so this is something that I am very proud that you guys have, and ladies, have showed up and want to join the licensed market. But a question I'm going to start with Mr. White, and anyone else can respond to this question. You're asking for a delay. As you're aware, cannabis is not federally legal. So in order for you to sell cannabis in DC, it has to be grown in DC. And it would appear that we're trying to be very aggressive with the cultivators. But the cultivators are saying, well, we're not growing because we only have a limited amount of dispensaries. So how then, or how are you asking us to delay the process if it's the chicken or the egg process, where the cultivators are saying, because there are sufficient, I believe, sufficient cultivator license out there. And there are cultivators who are not utilizing their license currently. So how is it that you believe that this board can grow more product? Because if you come on board, then we can say to the cultivator, because as you've known, there's no plant count. So therefore they can grow as much as they can. So we have eliminated the plant count, it's way back. But now you're asking us to delay the retailer process. But if I was a cultivator, why would I want to come in the market? Because if I don't know who the consumers are, there are currently only 7 dispensaries. So you explain that to me. I'll start with Mr. White, and whoever else can join in after.
So thanks for your question, Chairman. What I would say first and foremost is, there are 7 dispensaries, medical dispensaries currently. As I testified, there's only about 2,000 pounds of cannabis being sold on the medical side. You got 5 out of those 8 cultivators actually are at growing. 3 of them are not even growing anymore because they abandoned DC altogether. You got 13 to 15,000 medical cards. The problem is that even onboarding the 20 or 30 licenses or more that you're talking about, you still wouldn't have enough cultivators. If they join, if 30 licenses came on board tomorrow, you will be right back at square one. So they can tell you anything that they want to tell you. I've talked to 2 of the medical actually operators. They don't have enough cannabis for these particular operators, and then they're price gouging them. You got one particular operator buys majority of the cannabis because they own a bigger pie of the medical operator. They're the biggest operator, so they own a bigger piece of the pie. So you're asking us to say, okay, why are we asking for you guys to halt the process? Number one, I think it needs to be looked at, the cultivator process needs to be looked at in a different way. Ensuring that plant disease are, number one, through matrix, are actually correct. Number two, let's start about how you plan on adding these other licenses and how much cannabis is actually being grown. 8,000 square feet of cannabis is not enough. So if that's the case, you're going to be right back to square one. So they're telling you all of this stuff, but they're not giving you the facts.
But how can I convince you to grow? What can I do? Because I hear you, but that's what I'm trying to say to you. How can I convince you to grow? Because there's sufficient that the market can support you growing more.
Well, number one is you got to take the handcuffs off of these medical dispensaries, as I talked about, in terms of them doing the marketing, advertising that they need to increase the client base. If you don't have participants in order to as we call them, footsteps, or people through the door, the supply will always be that way. But you have to allow operators to operate like operators. Allow them to be normal businesses. And if you do that, then you can expand on cultivation. If you don't have enough product, which seems like that's been the overall testimony, not only from us, but also other people outside of the I-71 committee, telling you that, hey, there's not enough cannabis being grown. Well, enough cannabis being grown is because not enough people are on a medical side. They don't have the numbers. And we know that the obstacle is federal, that people work with the feds, even locally. You can't have a medical card if you're even state government. There's different things that happen. So therefore, that limits the opportunity. The reason that the I-71 committee or community is so successful is because people want to be free will. You can't have that. And I speak to everybody in the industry as the chairman. We are I-71 compliant. I speak to those who are not I-71 compliant. I speak to medical, and it's all the same consensus. When you have the lack of cannabis and also in tune with bad product, even with the product that's actually being grown, not quality product, you're going to have this problem. So I urge you to take a look at the cultivation, look at the product, look at how much is actually being grown. See the sale, it's matrix, it's real simple. And if the numbers don't add up, if the quality don't add up, then there's lies the problem. If you're asking us, I want to be medical, I want to be legal, I want a license to come aboard, we have to get this problem resolved first and foremost. Because if we don't get this problem resolved, you're still going to have a huge black and illicit market. And it's going to be the same conversation year in and year out. I promise you that.
Anyone else want to respond? And I see that Ms. Clark had you could put your answer in the chat, ma'am, and we'll try to see if I can elevate that. That's to you, Ms. Clark, if you can synthesize an answer to put in the chat. But does anyone else want to comment on that question? All right, well, I'm just saying, so the forum is open because that's what it is, as you will see, we will be as aggressive as possible to have the cultivators cultivate. But
let me ask you a question.
Yes, sir.
If you have 8 cultivators, 5 have all pretty much gone to other states. You got 3 of the 5 basically, most of their cannabis is going to one dispensary. You guys don't see that lies a problem there?
But no, but I'm not saying, what I'm saying is that on one hand, cultivators are saying that they don't have a large enough market. As you are aware, we don't have a legal recreational market in DC because of Congress. So therefore, we do not have a legal recreational market in DC. So therefore, we only have a medicinal market. So that's we can't control that. And so
that's true. But
because of Congress, right? But I'm saying but what we can control, as you can see, the board and the agencies, we have been very expansive in expanding the medical market, the dispensary market. But I am not quite sure how is it that we can convince, because even if you're saying we can advertise, okay, so all right, fine. Say all the dispensaries can advertise, okay? The dispensaries can advertise, but how can we force because you've stated that some of the cultivators have left DC to go to go somewhere else. They might go to Maryland. They're focused in Maryland. So the larger issue is that if you don't come on the market for the cultivators to say, okay, there are now 30 licensed establishments there. So therefore, there's a larger pool of retailers purchasing my product. So therefore, I can grow more.
So here's the thing.
Right.
Here's the thing. Even if those 3 came back, look at their footprint. All of them are less than 10,000 square feet. It would take 18 months. Some of them have let at pretty much, we don't know, outdated equipment. So let's say in a perfect world, a year to get back up and running. That's still not going to resolve a problem. That's you're just basically putting a Band-Aid over a wound. If you take
I'm sorry. I want solutions, and I said before,
and what we do as the I-71 committee, we sit down and we bring solutions. We look at things internal, external. We find solutions. We don't want problems. We ask for solutions. That's all I ask the committee to do, day in and day out. Let's find a solution to these problems. But when we're speaking overall, overarching, everyone agrees with us. It's just not the I-71 committee. It's medical. They feel the same way. It's just not us that feels this way. We're operators. We understand. And I guarantee you, if you take a consensus, your poll will come up to say, let's halt this. Let's get the cultivating side right. Let's not be New Jersey. Let's not be Illinois. Let's get this thing right.
And I'm coming to you, Mr. Grandis, but I hear you. But what incentive can be granted to the cultivators for them to grow? Because if it's put in a pause. I'm speaking for myself, and I'm speaking while we're here, right? Is that you're saying put a pause, but we put a pause on it. The cultivators are going to say there's not sufficient market. So there's not a sufficient market for me to.
There is a sufficient
Can I interject, sir? May I interject?
Go ahead. Go ahead, Miss.
Chairman, I completely understand your hesitation, especially given the current market. But as we start enforcement and as competition disappears from the I-71 committee, the market dynamics are going to be completely different once these retail stores start shutting down. These operators are generating millions of dollars a year. They're pumping out pounds, hundreds of pounds of marijuana coming from out of state. In order to not create a vacuum effect and send this all straight back to the black market, there needs to be cultivation in place. We have to measure what's going on in the I-71 committee now and kind of use that as a gauge to predict what the market's going to look like. And I think that's enough incentive to potentially bring on growers when they understand what is about to happen once this I-71 dynamic is no longer in the picture.
And then, could I? Well,
Just identify yourself before you speak, okay?
Sorry, this is Stephen Slaughter. And to go on to what Barbara's saying, even for the new cultivators that will be applying for licensing and coming on board, they also need time to set up their shops, to set up their, the warehouses. The space also has to be set up along with the time frame for grow just in general. So even the incentive for the existing cultivators as we exist right now, their incentive is that these new shops that are coming on board currently, they're still going to need to purchase as they get their licensing, especially the first round of the sociable, equitable applicants as they come through and their shops start to open up. The new cultivators still won't be ready to help those shops. So the current cultivators, the initiative for them would be that you're going to have these shops coming on board. They know that the illicit market right now is very big. And by transitioning, just like Barbara said, there's going to be a lot of I-71 shops that start to close out. And therefore that they should anticipate that their market is going to grow rapidly, really quickly when this all happens.
Yeah, and dovetailing onto that, we're just talking about flower here. We're not talking about the biomass that it takes to create products like tinctures and edibles and things of that nature. So that has to be taken into consideration too with the cultivation, because that's the first step in the manufacturing process. It takes far more biomass to create products like that than it does to just smoke it. So I'm not sure that was taken into consideration when formatting this structure. And that's something that needs to be considered moving forward.
Yeah. Smooth, did you have something you want to say? And then Mr. Grandis, you can ask your question.
Yes, it's Christopher Smoot. I just wanted to say that I agree with what Barbara is saying. Not only do you have to think about do they have to cultivate for just the demand for flower, but they do also have to increase the amount that they cultivate to support the demand for extracted products and products that are created with the extractions. So it takes a lot more biomass to make something into an extraction. And then it takes time and research and development on top of that to develop that extraction into an edible or a inhalable or a vapable product. And so for all of the new manufacturers, they'll have to go through that process and that time and that development. And that will just add a whole nother essentially padding on to when any newly licensed business could actually release their products to the public and to new retail operations.
Thank you. Mr. Grandis, did you have a question you want to answer?
As I said earlier, I as a board member, finding all of this very enlightening, and we very much appreciate you all taking the time to come and talk about your struggles. I just think it's you all have highlighted things, and all the other panelists have highlighted things that we will go back and talk to the agency about. Can we get away from the product for a moment? We all know that's very legitimate that you're bringing up, but you all have this sophisticated group or committee called I-71. Are you all doing anything to get people who participate in that committee to know what is happening in the future, in the short term? Are you all doing anything to say, do you all have security at the door so people under 21 do not come in to our gift shop? Do y'all have anyone that is really knowledgeable? Well, I'm just saying, I appreciate the concerns you're raising, but you're raising them to me as illegitimate businesses. Okay.
Well,
So
let me stop you right there.
Wait a second, Mr. White. No, you're not going to stop me right there.
Mr. Grandis, you asked a question he was trying to answer, but finish your question.
No, my question, let me get to my question. Are you all doing any educational opportunities for people like yourselves who we want to help bring into the legal market? We do support getting you all into the legal market, but are you all doing educational programming about all the other characteristics that our dispensaries have to go through right now? That's what I'm just wanting to know.
And that's what I'm trying to answer. So first
Thank
and
you, Mr.
foremost,
White. Yeah,
we do have a security plan in place. That's first and foremost. I pay a security company a healthy amount of money every week to secure my store. In terms of education, we educate not only the client, but we also educate the community. We have PR teams that actually, as we involve the community in a lot of aspects of what we do as being I-71 compliant. We pay taxes to DC government. We do a lot of things for the community that the medical community doesn't do. We fundraise, coats for kids. I think the notion is that we make money and we don't give back. So let me make this very clear. As the chairman of the I-71 committee, each month we do something for someone or somebody in the community from a voluntary standpoint. From terms of making sure that people are 21 and older, we check ID. Majority of us hire armed securities to make sure that no one robs our store or bring violent or crimes. In my particular case, I also give money to the Mount Vernon bid to make sure that the security is properly not only for my business, for all businesses. In terms of education, everybody that's hired by Monco, which I own here at 444 K Street, we go through an educational about every product that we have inside our store. That product is not only do we talk to a customer, but if you go online, the first thing they talk about is how we educate in our customer service. So most businesses, if not all businesses, with that's I-71 compliant. Let me make that clear. That you see that check mark in the window that's saying that, hey, we have a C of O, we have a business license, we pay taxes. Those are the businesses that we represent. We do external and internal education as well as community service. So that's would be my answer to your question, sir.
And thank you, because I think that's really very helpful to me to hear that, because we need to get people into compliance. So what you're doing sounds extraordinary and very much welcomed. What about if I were to come in and get a product, how do I know it's safe? Who does your test? Who does your testing? I'm not saying you, a particular company, but part of the I-71 committee is testing the product, something you all are helping other I-71 people to learn how to do.
Well, currently we self-test, just like every dispensary in the city. No, there's no testing facility in the city. But we make it clear that the products that we get that's put on the shelves are safe. We have not one problem that's been reported to you guys, the DOH or the city DCRA from the I-71 side. As those people who are I-71 compliant, these are things that we talk about week in and week out in our meetings. How to make it a safe environment, not only from a safety secured standpoint, but from a consumption standpoint. We're very clear about that.
Thank you. And like I said, this has been a good education for me. And that's why I think having these kind of hearings is very helpful for both sides of the equation. But thank you very much. And just so you understand, I personally support the I-71s coming into compliance and having legal licenses, just so you understand that, because I'm not trying to put anyone down or say that you all are not having a good legal operation. But we
I
do
appreciate that.
You're right. We do need to help each other get into compliance.
All right, Edward.
Thank you, Mr. Chairman.
Well,
Go ahead, Mr. Slaughter.
This is Steve.
You're welcome, Mr. Grandis. Yes, Mr. Slaughter.
Yes, I just wanted to also to back off of what Terrence is basically saying. We also have a part of being a part of the Initiative 71 committee is we've had people come on board and on our weekly calls from different states who have already gone through regulation from states like on the West Coast. And we've had different representatives that have worked in compliance areas, law firms, just educating the committee owners of the businesses that we currently have on how the processes have come into place in other states that are now legal. So for example, I've been with the committee for just about 2 years now. And I could tell you that for the stores that are with the Initiative 71 committee, if you were to look at something like gummies, for example, and I just seen a comment that was mentioned above about things being found in gummies and some of the illicit stores. Well, we've made changes to whoever's a part of the committee to make sure that the gummies that they're carrying on their shelves, that they get labeled correctly, that the products are labeled correctly, and that we're moving towards a regulation, because there's not a regulation set in stone for us, but to be more in line with states who have already legalized. We've taken those steps in our own committee so that the consumers that are getting products from us, they are also, they're feeling safe based on the regulations that other states have passed that we've also been bringing into our committee to fall in line with what medical is already doing in DC as well.
All right. This is as I stated before, this is important. This panel was not planned this way. The way the panels were created, I called the witnesses based on when they registered for the agency. And so that's how we started. And it appears that the I-71 committee was the last group of folks who signed up to testify. And so this is actually a great way to end our public hearing, because this is actually the first public involvement that this board has had with the I-71 committee for us to hear where you are, what are your wants, and try to see if what can be done through these regulations and and through the law, if changes have to be made by the council to ensure that you are able to transition into the licensed market. And so I do applaud the fact that you're here today. And so it shows me that especially the I-71 committee that who's operating in the district, that you want to access the legal market. And we will do what can be done to ensure that you're able to access the legal market. I would ask that we'll be having some fact finding here in the coming weeks with some cultivation centers. And so I'll ask that you look at our schedule to see what hearings that we're having, because we'll be having some hearings regarding cultivation centers and the fact that some of them are not using the license, and maybe you can, it's not open for you to participate in, but then at least you can hear what they are saying, why it is that the license is not being utilized. And so, as I stated before, we're here in a position, we want you to join the licensed market, the legal licensed market. And the cultivators are saying that we're not growing because the market is not large enough. And so if we were to, and I don't know what to do, because you're saying we should postpone, they're saying the market is not large enough. That's why I'm not growing. And so we have to come. And so I support whatever conversation that you have with our agency director, because so you can share with them what your plans are. And because unfortunately, this is your only opportunity to meet with us, because if you meet with us, it has to be in a public hearing. So we can't meet with you unless it's a forum like this. And so, but I do appreciate the views that were expressed today. And I just want to thank all those who took the time today to testify to this hearing. Please know that this is not your last opportunity to share your thoughts with the board. Written comments can be submitted to the board following this hearing until June 21st, 2023, and during the 30-day comment period when the rules are published in the DC Register. Please send your comments by email to abca.legal@dc.gov. Thank you very much for your presentation today. It was very helpful, and I think that this is the largest public hearing. I've been chair for 7.5 years, and we have been regulating cannabis for about 4 years, and this is the largest public hearing we have ever had, and it's been a virtual hearing, and basically I would say without any hiccups. I mean, we've been online since 10:45 this morning, and I believe we only had 1 or 2 persons with technical issues. I think that is a success that we've been able to have a virtual hearing, and almost 100% of the folks have been able to participate. So thank you very much for your participation today, and have a great day. And we will take all the comments that we have received in making changes to the regulations. That I know a lot of comments will be statutory changes. So if you are able to go to the city council and ask for changes, yes, you can do that. We will, as far as within the confines of the law, we will try to see what we can do. But a lot of the changes that I think are being requested today can only be addressed by the council. And so if you're able to have the council make those changes, the board will do whatever we can do in our position to make changes. Okay, so have a great day, and thank you very much. This hearing is closed. All right, so I want all board members to remain on board so we can finish our agenda items for the day. All right, thank you. All right. So now we have finally concluded our public hearing on the rules, and so let us now do our legal agenda. The first matter on our legal agenda, it's a review of an offer and compromise in lieu of a hearing date June 6, 2023 for case number 23 CMP 00029 Tres Creole Catering, license number 111150. The offer and compromise is that charge one failed to provide prepared food with sale, service, and consumption of alcohol. It's a first primary tier violation, statutory authority, DC Code Section 25113I2 and 23 DCMR Section 2000.1. The fine is $1,000 payable within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Charge two, failed to produce requested records within 48 hours. This is the first primary tier violation, statutory authority, DC Code Section 25113I4 and Section 25823A5. There is a $1,000 fine payable within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Charge three, no owner or ABC manager, first secondary tier violation, statutory authority, DC Code Section 25701. There's a fine of $250 payable within 30 days, or the license shall be suspended indefinitely. I make a motion that we accept this offer in compromise. Is there a second?
Jenny Hansen will second.
Ms. Henson, I second the vote. We'll have a roll call. I'm sorry, Ms. Henson, I second the motion. We'll have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. Number two, review of a settlement agreement dated May 24th, 2023 by and between Advisory Neighborhood Commission 1E and Amina Market Wine and Spirits, license number 122253. I make a motion that we approve this request. Is there a second?
Grandis will second.
Mr. Grandis will second the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number three, review of a settlement agreement dated June 2nd, 2023 by and between Advisory Neighborhood Commission 2B and Ampora Fundito, license number 124404. I make a motion that we approve this request. Is there a second?
Grandis will second.
Mr. Grandis will second the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number four, review of a settlement agreement dated June 3rd, 2023 by and between the Kalorama Citizens Association and Tess Hay Restaurant and Bar, license number 124493. I make a motion that we approve this request. Is there a second?
Bobby Cato seconds.
Mr. Cato, second the motion. We'll now have a roll call vote. Mr. Short, I'm sorry, Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. Number five, review of a consent motion to consolidate and continue protest hearings dated May 31st, 2023 in case number 23PRO00015 and case number 23PRO00046, Tom's Watch Bar, license number 119403. I make a motion that we approve this request. Is there a second?
Jenny Hansen will second.
Ms. Henson, I second the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number six, review of a correspondence from Councilmember Brianna K. Nadeau dated June 1st, 2023, regarding her support for the creation of a moratorium zone for the North Shaw and Ninth Street neighborhood. This is an FYI for the board. We now move to our licensing agenda. The first matter on our licensing agenda is a review application for a stipulated license with letter of agency support for a new ABCA license. This is for Ridge Club, license number 124582. I make a motion that we approve this request. Is there a second?
Jenny Hansen will second.
Ms. Hanson has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. Number 2, review application for safekeeping of license. This is for Tigerella, Tigerella, license number 119978. I make a motion that we approve this request. Is there a second?
Cato, seconds.
Mr. Grandis and Mr. Cato second the motion. We'll have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 3, review application for safekeeping of license. This is for Lucky Bar. The Tigerella. That we voted to approve the safekeeping through September 30th, 2023, if I had not mentioned that. For Lucky Bar, this is also a review of a safekeeping request, and I make a motion that we approve the safekeeping through September 23rd, 2023. This is for Lucky Bar, license number 020234. Is there a second?
Jenny Hansen will second.
Ms. Hanson has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 4-0. Number 4, review application for safekeeping of license. This is for City Corner Market. I make a motion that we approve this request through September 30th, 2023. Is there a second?
Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 4, review application for entertainment endorsement. This is for Pico/Nema Co. license number 093610. I make a motion that we approve this request. Is there a second?
Jenny Hansen will second.
Ms. Henson has seconded the motion. We'll have a roll call vote. Mr. Cato.
Cato, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 6, review application for change of hours. This is for Neptune Room, license number 109739. I make a motion that we placard this matter. Is there a second?
Jenny Hansen will second.
Ms. Henson has seconded the motion. We'll now have a roll call hearing. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0. Number 7, review application for change of hours for Sidewalk Cafe. This is for the Showtime license number 089186. I make a motion that we placard this matter. Is there a second?
Cato, seconds.
Mr. Cato has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 8, review request to increase the total occupancy load of the establishment from 21 to 44. This is for Kids KIDST Lounge, license number 119361. I make a motion that we placard this matter. Is there a second?
Cato, seconds.
Second.
Mr. Cato second the motion. We'll now have a roll call vote. Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0. Number 9, review application for a class change from retailer C Restaurant to retailer C Tavern. This is for Kids Lounge, license number 119361. I make a motion that we placard this matter. Is there a second?
Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 4-0-0. Number 10, review application for entertaining endorsement inside the premises only. This is for Kiddes Lounge, license number 119361. I make a motion that we placard this matter. Is there a second?
Bobby Cato, second.
Mr. Cato and Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 4-0-0. Number 11, review application for Sidewalk Cafe with 12 seats. I make a motion. This is for Matisse Bar and Grill, license number 025496. I make a motion that we refer this matter back to licensing. Is there a second?
Grandis will second.
Second.
Mr. Grandis and Ms. Henson second the motion. We'll have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 4-0-0. Number 12, review application for an off-premises storage permit endorsement to store alcoholic beverage inventory off-site at 2903 Sherman Avenue Northwest. The request is made from Harvard Liquors, license number 114547. I make a motion that we approve this request. Is there a second?
Edward Grandis will second.
Jenny Hansen, I'll
Mr. Grandis
second.
will second the motion, and along with Ms. Henson, we'll have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Agrees.
and Mr. Anderson, I agree. The matter passed 4-0-0. Number 13, review a request for approval to provide a gift of Alicia Keys concert tickets that does not exceed $500 in value to various licensed retail and establishments. This is for, the request has been made from Breakthrough Beverage, license number 060518. I make a motion that we approve this request. Is there a second?
Jenny
Bobby
Hansen,
Cato,
second.
seconds.
Mr. Cato and Ms. Hanson, the second motion, will have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 4-0-0. We now move to our notice of supplemental licensing agenda. The first matter on our notice of supplemental licensing agenda, review request for temporary operating retail permit. This is from Thompson, Washington, D.C. /Anchovy Social /Malera Mayor, license number 125078. I make a motion that we approve this request. Is there a second?
Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passes 4-0-0. Number 2, review request for approval to provide a gift of tacos for a promotional event that does not exceed $500 in value to Corner Market. This is from Breakthrough Beverage, license number 060518. I make a motion that we approve this request. Is there a second?
Bobby Cato, seconds.
I'll second.
Mr. Cato has seconded the motion. I think Ms. Henson has also seconded the motion. We'll now have a roll call vote. Mr. Cato,
Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. The matter passed 4-0-0. We now move to our notice of meeting medical cannabis licensing agenda. The first matter on our medical cannabis licensing agenda, review of a medical cannabis retailer's endorsement application to add delivery and education tasting endorsement. This is from Herbal Alternatives, license number 117377. I make a motion that we approve this request. Is there a second?
Bobby Cato, seconds.
Mr. Grandis and Mr. Cato second the motion. We'll have a roll call vote. Mr. Cato,
Bobby Cato, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
And Mr. Anderson, I agree, the matter passed 4-0-0. Number 2, review of a medical cannabis retailer's endorsement application to add delivery and educational taste and endorsements. This is for Anacostia Organics, license number 117379. I make a motion that we approve that request. Is there a second?
Bobby Cato seconds.
Mr. Cato, second the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
Mr. Anderson, I agree. The matter passed 4-0-0. Number 3, review of a medical cannabis retailer's endorsement application to add delivery endorsement. This is for Cannabliss, license number 117380. I make a motion that we approve this request. Is there a second?
Second.
Mr. Grandis is second the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Mr. Grandis.
Grandis, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 4-0-0. Number 4, review safekeeping status of cultivation center license in progress of construction pursuant to temporary closure due to a damaging fiscal year 22 fire. This is for Organic Wellness, license number 117371. I make a motion that we have a fact finding hearing. Is there a second?
Grandis will second.
Mr. Grandis is second the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number 5, review status of placarded transfer of location to 2046 West Virginia Avenue. This is for Holistic Remedies, license number 117369. I make a motion that we have a fact finding hearing. Is there a second?
Jenny Hansen will second.
Ms. Henson has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number 5, review status of safekeeping and approved conditional transfer of location for Medical Cannabis Cultivation Center at 6500 Chillum Place Northwest. This is for DC Finest, license number 117367. I make a motion that we have a fact finding here. Is there a second?
Cato seconds.
Mr. Cato has seconded the motion. We'll now have a roll call vote. Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. All right. We move to our board temporary license and 1-day substantial change docket. On this docket, there are 43 licensees. So I'm going to give the name, the type of license that they request, the event, the date of the event, the license number, and the attendees. And at the end of the list of 43, I would make a motion that the ABC board grants these temporary license. The first request is from Lana Mahmoud, for 1-day license class F, for concert. This is on June 24th. The license number is 124923, 800 attendees, 10 security guards. Number 2, another request from Lana Mahmoud, a 1-day license class F, concert live music performance. This is on June 8th. The license number is 124924, 350 attendees, 6 security guards. Number 3, another request for Lana Mahmoud, a 1-day license class F, concert live music performance. This is June 10th, 2023. The license number is 124930, 350 attendees, 6 security guards. Number 4, another request from Lana Mahmoud for a 1-day license class F, concert live music performance, June 15th. The license number is 124926, 350 attendees, 6 security guards. Number 5, another request from Lana Mahmoud, a 1-day license class F, concert live music performance, June 23rd. The license number is 124931, 350 attendees, 6 security guards. Number 6, another request from Lana Mahmoud, a 1-day license class F, Live concert, live music performance, June 14th, 23. License number is 124928, 500 attendees, 10 security guards. Number 7, another request from Lana Mahmoud, a one-day license class F, concert, live music performance, June 28th. The license number is 124929, 500 attendees, 10 security guards. Number 8, a request from Alicia AYSHA Corbett, a one-day license class F, live music performance, June 9th. The license number is 124975, 150 attendees, three security guards. Number 9, a request from Mary Lesher, one-day license class F, live performance. This is June 7th through June 9th. The license number is 124995, 100 attendees, 4 security guards. Number 10, a request from Mary Leshner, a one-day license class F, museum tour, June 15th. The license number is 124996, 100 attendees, 4 security guards. Number 11, a request from Christopher Cushman, a one-day license class F, family picnic, June the 11th. The license number is 124998, 300 attendees, 6 security guards. Number 12, a request from Emily Morrison, a one-day license class F, fundraiser, June 10th. The license number is 125008, 75 attendees, 2 security guards. Number 13, a request from Merrill Groeschel, Groeshel, a one-day license class F, Solutions in Hometown Connections fundraiser, June 22nd. The license number is 125018, 50 attendees, 1 security guard. Number 14, a request from JC Max, one-day license class F, Paint and Sip Gallery opening, June 8th through June the 11th. The license number is 125026, 75 attendees, 2 security guards. Number 15, another request from JC Max, one-day license class F, Paint and Sip Gallery opening, June 15th through June 18th. The license number is 125027, 75 attendees, 2 security guards. Number 16, a request from Sheridan Small, a one-day license class F, architecture lecture by Ronald Reel. This is June 16th, 2023. The license number is 125075, 70 attendees, 2 security guards. Number 17, another request from Sheridan Small, a one-day license class F, architecture lecture by Sushi Reddy. This is July 17th, 2023. The license number is 125076, 100 attendees, 2 security guards. Number 18, a request from Krishon, CRSHON Landers, a one-day license class F, summer concert series, June 9th. License number is 125082, 150 attendees, 3 security guards. Number 19, another request from Krishon Landers, a one-day license class F, summer concert series, June 16th. License number is 125083, 150 attendees, 3 security guards. Number 20, another request from Krishon Landers, one-day license class F, summer concert series, June 23rd, 2023. License number is 125084, 150 attendees, 3 security guards. Number 21, a request from Krishon Landers, one-day license class F, summer concert series, June 30th, 2023. The license number is 125085, 150 attendees, 3 security guards. Number 22, a request from Bedidal, Betilde, Munzo, MUNOZ hyphen POGASSIAN, a one-day license class G. This is for Quinceañera, QUINCEANERA. This is June 9th. The license number is 124955, 150 attendees, 3 security guards. Number 23, a request from Ryan Boss, a one-day license class G, DC Pride Parade, June 10th. The license number is 124978, 2,000 attendees, 20 security guards. Number 24, another request from Ryan Boss, one-day license class G, DC Pride Parade, June 11th, 2023. License number is 124979, 100,000 attendees, 49 security guards. Number 25, a request from Zachary Coles, one-day license class G, soft opening June 8th, June 7th through June 9th. The license number is 124984, no more than 89 attendees at one time, 4 security guards. Number 26, a request from Zachary Coles, one-day license class G, soft opening June 10th through the 11th. License number 124986, no more than 89 attendees at one time, 4 security guards. Number 27, a request from Zachary Coles, one-day license class G, soft opening June 14th through June 16th. License number 124987, no more than 89 attendees at one time. Number 26, another request from Zachary Coles, one-day license class G, soft opening June 17th through June 18th. License number is 124988, no more than 89 attendees at one time, 4 security guards. Number 29, another request from Zachary Coles, one-day license class G, soft opening June 21st through June 23rd. License number is 124989, no more than 89 attendees, 1 security guard. Number 30, another request from Zachary Coles, one-day license class G, soft opening June 24th through the 25th. The license number is 124990, no more than 89 attendees at one time, 4 security guards. Number 31, soft opening Zachary Coles, one-day license class G, June 28th through June 30th. License number 124991, no more than 89 attendees at one time, 4 security guards. Number 32, a request from Kalisha Akil Dia Villieri, a one-day license class G for fundraiser, June 10th. License number is 124994, 75 attendees, 5 security guards. Number 33, a request from Tesfit Iman, EMAN, conference, June 10th. The license number is 125013, 300 attendees, 3 security guards. Number 34, Sunderpreet Sandhu, SUNDERPREET. The last name is SANDHU, a one-day license class G pre-wedding event, August 10th. License number is 125070, 80 attendees, 2 security guards. Number 35, Deanne Bussy Reed, one-day license class G grand opening, June 14th. The license number is 125070, 500 attendees throughout the event, 25 security guards. Number 36, Uproar, one-day substantial change, event market June 9th through June 11th. The license number is 092012, substantial change, license is 23SC00758. Number 37, Aqua 301, one-day substantial change. This is for Rose All Day, June 17th, 2023. Change to use license off premises as a participant in the Yards Rose All Day event at Yards Park. The license number is 092094, substantial change, license 23SC00761. Number 38, La Famosa, one-day substantial change for Rose All Day, June 17th. Nature of substantial change, change to use license off premises as a participant in the Yards Rose All Day event at Yards Park, license number 115848. Substantial change numbers 23SC00762. Number 39, Schilling Cannon Company, one-day substantial change, Rose All Day event, June 17th. Nature of substantial change, change to use a license off premises as a participant in the Yards Rose All Day event at Yards Park. The license number is 106038, substantial change, license 23SC00763. Number 40, the Alibi/Maxwell one-day substantial change, Rose All Day, June 17th. Nature of substantial change, change to use license off premises as a participant in the Yards Rose All Day event at Yards Park. The license number is 115589, substantial change, license 23SC00765. Number 41, Asteria Marina /Nico /Letta /Morini /Piccolo. One-day substantial change, Rose All Day, This is on June 17th. Nature of substantial change. Change use the license off premises of a participant in the Yards Rose All-Day event at Yards Park. This is on the license number 092083, substantial change license 23 SC 00766. Number 42, Brightwood Pizza and Bottle, one-day substantial change, Jazz Music Festival. This is June the 11th. The license number is the nature of substantial change. Change use license off premises at 1010 Butternut Street Northwest for outdoor jazz festival at Walter Reed Marketplace Plaza. License number is 102866, substantial change license 23 SC 00780. Number 43, Premium Distributors of Washington, D.C., one-day substantial change. This is for D.C. Pride Parade. This is June the 11th. Nature of substantial change. Allow delivery of alcohol on Sunday to Capital Pride Alliance for Pride Festival on same day. License number 060290, substantial change license is 23 SC 00784. I make a motion that ABC board approves all these licenses. Is there a second?
Cato seconds.
Mr. Cato, second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. All right, we have the second part of our one-day substantial change license. We have 4 events that occurred, and I make a motion that the ABC board approve these events, although they have already occurred. So the first one, so I'm going to make a motion that they be approved, although the events occurred while the board was on the board was not in session because of the holiday last week. So the first request is Lana Mahmoud for one-day license class F. This was on June 1st. The license number is 124909 510 security guards. The second request was another request from Lana Mahmoud concert. June 2nd, license number is 1249133 attending 6 security guards. Number 3, another request from Lana Mahmoud concert. This was June 5th. The license number is 124914 800 attendees, 10 security guards. Number 4, another request from JC Max, one-day license class F, paint and sip grand opening. The license number is 124999 75 attendees, 2 security guards. Number 5, a request from Steve Bilodas, a one-day license class G VIP cocktail reception. This is June 1st. The license number is 124948 200 attendants, 4 security guards. Number 6, a request from Courtney Nelson, a one-day license class G private event June 1st through June 8th. The license number is 124906 250 attendees, 5 security guards. Number 7, a request from Carla Teixeria, one-day license class G cocktail reception. This is June 6th. The license number is 124941 100 attendees, 2 security guards. Number 8, request from Premium Distributors of Washington, D.C. LLC, one-day substantial change. The Wonderland Ballroom Fundraiser Festival. This was June 4th. Allow delivery of alcohol and send it to retailer Wonderland Ballroom for fundraiser festival on the same day. The license number is 06290, substantial change license 23 SC 00781. And number 9, a request from Illy DC, one-day substantial change private event. This is on June 5th. Nature of substantial change is licensed off premises in the fire pit area adjacent to the establishment for corporate social event. The license number was 118113. Substantial change is 23 SC 00782. I make a motion that the ABC will retroactively approve these requests. Is there a second?
Mr. Short, I second.
Grandis will second.
Mr. Short and Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Grandis,
Grandis, I agree.
and Mr. Anderson, I agree. The matter passes 5-0-0. We now move to our licensing agenda. On our licensing agenda, there are 12 applicants. I'm going to read the names of all applicants. I will give the class type of license that they have and the requests that they have been made. That's been requested. At the end of the list, I'll ask the ABC board to approve these licenses or these changes to these licenses. The first request is a personal importation permit application from James Belinga, Belinga. The license number is 23 IMP 00013. The second request, a request from Darren K. Hunter. This is for also a personal alcohol importation permit application. That license number is 23 IMP 00014. Number 3, a request from Johnny's All America, license number 123033. Their retailer C Tavern, change of officer application. Dinah H. Givan, Givand, is now a member. Number 4, Freighters on the Alley, license number 108886, retailer C Tavern, trade name change application. The new name is Bar Chinos. Number 5, Zachary's, license number 23SC00783, storage permit application, trade name change application. The new name is Zachary's Fine Wine Storage. Number 6, Shipley Supermarket, license number 123533, retailer B, beer and wine, change of hours application. Number 7, Other Half Brewing, license number 114148. They are manufacturer B. Class change application from manufacturer B to retailer C Tavern, brewpub endorsement, entertainment endorsement, inside only, and change of hours of operation and alcoholic beverage sales and consumption for inside and outside in the 3 existing summer gardens. Number 8, Right Proper Brewing Company, license number 097516, manufacturer B, class change application from manufacturer B to retailer C Tavern and brewpub endorsement. Number 9, Rosebud Liquor, license retailer A liquor store, transfer to new location application. The new location is 1700 17th Street Northwest. Number 10, Amparo, Amparo, Fundita DuPont, license number 124404, retailer C restaurant, new ABC license application. Number 11, The Strand, license number 116798, retailer C restaurant, new license application. Number 12, Novel Grocery, license number 124413, retailer B, beer and wine, transfer without sale application. Number 13, The Royal Sanista Capitol Hill, license number 123801, retailer C hotel, new ABC license application. I make a motion that ABC board approve these applications. Is there a second?
Cato seconds.
Mr. Cato seconds the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Grandis stated that he agrees. And Mr. Anderson agrees. The matter passes 5-0-0. We move to our second licensing administrative docket. This is for the street tree endorsement. There are 2 applicants who wants the ABC board to add the street endorsement to the application. I'll name the names. At the end, I'll ask the ABC board to grant these changes. So the first applicant is the generator, license number 111618, retailer C Hotel Street Tree endorsement application. The second applicant is Chicana, Chicatana, fine Mexican cuisine. License number 116631, retailer C Restaurant Street endorsement application. I make a motion that ABC Board approves the addition of these endorsement to the application. Is there a second?
Cato seconds.
Mr. Cato seconds the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I
Mr. Grandis.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 5-0-0. And we move to our last agenda for the afternoon. And this is the Licensed Administrative Docket Alcohol Awareness Provider Certification Renewal. There are 3 providers on this application, agenda. I'm going to make a motion. I'm going to read the names, and at the end, I'll ask the ABC Board to renew their certification. So the first provider is State Certification Alcohol Awareness Course, license number 087423, Alcohol Awareness Provider Certification Renewal Application. The second applicant is Norman Nevison and Associates ACP, license number 087424, Alcohol Awareness Provider Certification Renewal Application. And number 3, it's Techniques of Alcohol Management TAM Training Program, license number 087435, Alcohol Awareness Provider Certification Renewal Application. I make a motion that ABC Board grants these renewals. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 5-0-0. And we are now at the end of all agenda items. And after, I will now close the hearing or adjourn for the day. All right, let me. All right. As chairperson of the Alcohol, Beverage, and Cannabis Board for the District of Columbia, and in accordance with Title III, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on June 28th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for June 28th, as published in the DC Register on June 23rd. Is there a second?
Grandis will second.
Mr. Grandis has seconded the motion. I will now take a roll call vote on the motion now that it's been properly seconded. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 5-0-0. As it appears that the motion has passed, I hereby give notice that ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board hearing room bulletin board, placed on electronic calendar on ABCA's website, and published in DC Register in as timely a manner as practicable. We're now adjourned for the day. I especially would like to thank the members of the public who participated today in our public hearing on our cannabis regulation. This has been a long day, and it appears that over 30 different individuals appeared to testify today. I would like to thank them for that. I also especially would like to thank all the board members. We have been online since 9:30 this morning without any break. And I would like to thank all the board members for their participation and their indulgence in us having this hearing. But I thought that rather break in for lunch and have the public waiting while we have lunch, and we'll just plow through it. So I just want to, again, thank all the board members who stayed with it the entire time. So thank you very much for your active participation in this hearing today. I want to thank the court reporter. Sometimes when I do this hearing, I try to take breaks because I need to remember that there are folks behind the scenes who are doing work that I'm not seeing. So I want to thank the court reporter who I did not stop and take a break, and I want to apologize because I forgot to take a break for the court reporter. So I want to thank the court reporter for his or her active participation this hearing today. And finally, I would like to thank our IT specialist, Mr. Jose Ariana, for his assistance today in assisting with this hearing and our public hearing in the sense of elevating the rights of everyone who needed to be elevated today. We had no technical, I would say that we didn't have any technical issues today. So I want to thank our IT specialist for his work today in making sure that this worked. We're now adjourned for the day. I will ask the board members to return to executive session for further development. Hopefully that will not be too long so we can go have lunch and go off. But thank you again and have a great day.